before we move to the next presenter. Over to you, Economic Freedom Fighters.
All right. Thank you very much. Now, submission on gender-based violence bills by Economic Freedom Fighters delegation, Commissar Sharon Letlape, Commissar Mbali Dlamini, and Fighter Leanne Mattheys, led by the Deputy Secretary General, Commissar Poppy Mailola. Now we will start with our submission, and it will be presented in the 3 bills. I will do the first one, and my other colleagues will do the 2 other bills. We would like to first thank Parliament and the Portfolio Committee on Justice for inviting us to make this presentation here. Even though we are the 3rd largest party in this country, with representative here in Parliament, we thought it prudent to come make this presentation here to emphasize just how important this work is for us. The work to nip at the bud the pervasive nature of gender-based violence is critical for the survival of women in this country, and therefore the survival of the nation as a whole. The scourge of violence against women, children, and lesbian, gays, bisexual, queer, transgender, intersex, disabled, and elderly people in this country is out of control. These violent practices may have received media attention in recent times, but have been perpetuated for generations and are deeply rooted in this country's history. The vicious cycle of triple oppression based on race, class, and gender has not been broken for Black women in particular. As a consequence of pervasive patriarchy and sexism in our country, it is Black women in the main who suffer the most from gender-based violence. The high levels of GBV that women face also reflect violence against sexual and gender minorities and people with non-normative bodies. In particular, corrective rape results in significant harm to lesbian, gay, and transgender people, as it is not just a sex crime, but a hate crime as well. It is estimated that 21% of women over the age of 18 years have experienced violence by a partner. In the South African and African context, GBV is widely used to refer to the violence waged against women, in particular because they are women. This violation range from verbal insults hurled at women in the streets to actual physical assault, rape, and the murder of women. In our founding manifesto, our position against gender-based violence is strongly made. The founding manifesto says, the EFF is against the oppression of anyone based on their gender, gender expression, or sexual orientation, meaning that we are against patriarchy, sexism, and homophobia in all of its manifestation. We are also against tribalism and religious and cultural intolerance. We oppose any cultural or religious practices that promote the oppression of anyone, especially groups that have been historically oppressed by such practices. The EFF will emphasize transforming the lives of our people in the ghettos from one of the generalized structural violence as a mechanism to end all violence, including violence against women. Our submissions: Criminal Law, Sexual Offences and Related Matters Amendment Bill. We welcome the inclusion of the National Register for Sex Offenders and the prohibition of having these sex offenders working anywhere they will be in contact with vulnerable people. We feel that this could be more explicit. However, Section 2 of the Act should be tightened to make it explicitly clear that the National Register for sex offenders is for anyone who has committed sexual offenses, and that these offenders must be barred from working with women and children, not just vulnerable groups. The definition of vulnerable groups may leave space for mistake to be made. We submit that there must be an additional subsection which states that there will be an alternative register for people who are accused of sexual offenses whose cases are still active. We welcome the expansion of the definition of incest to include cases where a child is sexually violated, even if there was a consent. But we submit that people found guilty of this offense must be found guilty of rape too, because a child cannot give consent. The definition of a person who is vulnerable in amended section 40C of the bill is very limited. From the lists in the bill, women over the age of 25 are not considered vulnerable. Our submission is that all women, regardless of age and class, are vulnerable to sexual offenses. The provision for removal from the register of sex offenders provided by Section 51 is not supported. We submit that people must only be removed from the register only when the court exonerates them. Offenders must stay in that register. What is happening? In that register for life. Okay. The amendments to Section 54 are very progressive, but we feel that they should be expanded further to include an obligation to report sexual crimes against women generally, not just children and people who are mentally disabled. Lastly, we submit that there must be an addition to the list of sexual offenses in the Act. This includes sexual coercion by a partner, forced marriage, ukutwala, also where a widower is forced to marry a husband's relative after his death, ukungenwa, stealing, refusal to pay sex workers for service rendered, and sex for jobs. Now, I will hand to my colleague, Commissar Sharon Letlape, to tackle the next bill.
Submission on Criminal and Related Matters Amendment Bill. We welcome the amendment to both the Magistrates Act and the Superior Courts Act to allow for intermediaries to enable younger witnesses suffer from a range of conditions that make it inconvenient for them to testify and be cross-examined. This will be a crucial intervention in the quest for justice. We note the stringent conditions, the amendments to Section 59, 59A, and 60 of the Criminal Procedure Act concerning the granting of bail for those accused of sexual offenses. These amendments, however, do not go far enough. It still leaves loopholes that offenders can use to get out of jail, and it discounts the toxic nature of society and families in particular, who may coerce victims of these crimes to testify that they have no problems with having perpetrators granted bail. Our submission is that there must be no bail at all for those accused of these crimes, and sexual offenses accused should be categorized as Schedule 5 and 6. They must only be released by the court at the end of the trial if found not guilty. The amendment to Section 299 of the Criminal Procedure Act must not include provisions for parole for those convicted of sexual offenses and murder of women during the commission of sexual offense. This is important. We submit anyone found guilty of sexual offenses should be sentenced to life in prison without the possibility of parole. The presidential pardon should not include those convicted of sexual offenses. I will now hand over to Commissar Mbali.
Submission on Domestic Violence Amendment Bill. We generally welcome the expanded definitions to domestic relationships and domestic violence. We're particularly happy that the definitions of domestic violence now includes coercive behavior and forced entry into places of residence and places of work without approval. The obligations created by amendments to sections 2A and 2B are comprehensive and will establish a societal pact to report cases of domestic violence to the police. We are also happy with the amendments of Section 3 and 3A of the Act, which allows peace officers to effect arrest without a warrant and to enter premises without a search warrant if there's a reasonable belief that a crime of domestic violence has been committed. The sections dealing with the protection orders are also comprehensive enough, and we are in support of these amendments. DSG.
Now, in conclusion, we acknowledge that various interventions must be made to uproot patriarchy, sexism, and reaffirm women's position in society. However, matters of gender-based violence are prevalent and need to be addressed immediately. This legislative proposition will go a long way in curbing the violence meted out against women. But this must be accompanied by other commitments by both the executive and the legislature. There must be a way of holding those responsible for operationalizing these laws accountable. Parliament must be an activist parliament against gender-based violence and take proactive decision to hold the executive to account on the implementation of these laws. In principle, we support these bills, provided the amendment we propose are taken to account. Thank you, and thank you very much.
Thank you very much to the EFF for the presentations, and you're within time. I will now note hands from the honorable members who would want to ask questions of clarity on the presentation that has been made by the EFF. I have noted Honorable Yoli Swayako, Honorable Kolangola, Honorable J.K. Mufokeng. Let me check if there are other members. Let me check the chat. No one. Okay, let's take the hands in that order. Let's start with, Honorable Kobo Delejanje. Let's take Honorable Yoliswa Yako as the first one.
Thank you very much, Chair. I feel like after Honorable Yankee has spoken, I might have to have a second bite because I'm sure something will go down there. But I'm grateful for the EFF bringing this. And Squaz, I would like to thank the EFF and its delegation for coming and making a very comprehensive and a very forward-thinking report to us as the committee. I also want to highlight some issues that I think have not been touched mainly, which are the rural practices that are done that do oppress women, such as ukutwala, ukuthenwa. We hardly ever speak about those issues which oppress women generally, and they oppress children as well, and border on incest, they border on, as rape. So I'm glad that we as the EFF have proposed that be stopped. Secondly, the fact that the status register should be on for life unless you are otherwise acquitted by the court. And lastly, I think that the executive, in particular the police, through the Minister of Police, should be held accountable for any amount of neglect on issues that are raised, on cases that are raised that are not taken into cognizance by the police. That should be taken very seriously by the committee, but also the justice system. Thank you very much.
Thank you, Honorable Yako. Honorable Ngola.
Thank you very much, Chair. Let's welcome the presentation, Chair.
Honorable Ngola, I'm not sure. Yes, you are very dark there. Now it's fine.
Can you see me now, Chair?
We can see you properly now.
All right, thanks. Chair, just one or two issues. One with regard to the call for no bail for the perpetrators of GBV. Chair, the current legal framework of the country, which has got the constitution as the supreme law, stipulates clearly that any law or conduct that is inconsistent with the constitution is invalid. Now let's go to section 35 of the constitution, which affords every accused or detained person a right to be given bail, which equally affords an accused person or detained person a right to be presumed innocent until proven guilty. I would presume that the EFF is aware of that. Then, in us crafting this legislation, how do they think we must balance this legislation with the constitution that provides for such rights for the accused and the detained? The last one, Chair, is that the last part of the presentation says the EFF supports these bills, provided their recommendations are considered to be part of the bill. Maybe just a little comment on it, that the lawmaking process starts, it's now here in the committee, it goes to the National Assembly, it goes to the NCOP, which some may believe that we may have been harsh or something. They may alter some of the provisions that we have made in the bill. It may come out with not everything that they submitted as the EFF. Will they then withdraw their support if such happens in the entire process of lawmaking? Thank you very much.
Thank you very much, Honorable Ngola. Honorable Jackie Mufokeng.
Thank you very much, Chairperson, and thanks for the presentation from the EFF. I just want to uncover, Chair, on the issue of the bail that was raised by Honorable Ngola. I want to check on the issue of parole, that people who are actually convicted on sexual offenses should not get parole. I want to check if they really check on the parole system, and are they happy with the parole system that is currently in place. The second part will be on the disciplinary of SAPS members who don't comply. Do you suggest there should be an oversight, and who should do it? Because there is something about those that don't comply. And on the issue of the orders, do you agree with those organizations that says the orders should be centralized? Noting a number of issues, among others, is that we have serial perpetrators or abusers. Thank you very much, Chair. Thank you, Chair. I think he's frozen.
Thank you very much. Thank you very much, Honorable Mufokeng. Honorable Kubutele Janji.
Thank you very much, Slalo. And let me also thank the economic freedom fighters with the leader of the delegation and the team for their presentation. I want to welcome it. just want to make a few comments, Chair. I think the first comment to make is we have listened to the ANC Women's League. We're now listening to the EFF. These are the two political parties that have come forward so far. I'm aware you are going to have a provincial government of the Western Cape, and I'm looking forward to that. But I think that the point to made, Chair, is that this is a societal challenge, and we can only defeat it if we take these matters of patriarchy, of lack of emancipation of women seriously, all of us. And with that, I wanted to check first with the EFF delegation. There is a pattern, DSG, that we have these laws, and yet problems are continuing. You continue to have women raped and all sorts of things done to them. With the laws in existence, yes, what we're doing now, we're tightening these laws. Has the EFF thought about, beyond the issue of tightening laws, was I was looking forward to hear that from the EFF. What else must we do as society to stop or to fight this scourge? Because resources, money, or laws alone, you have raised upfront the issue of patriarchy that we have in society. And so if you can comment on that first as to what you want to leave us with in this committee beyond the technical work that we must do in terms of the law. The second point is a request to yourselves as the EFF, just to follow up on Honorable Xola Nqola, that you are enriching this work of these bills that must become act and laws that are executed. The request, therefore, is because we have different ideas, people are going to share, people are going to engage. Let me give you an example so that you understand this request. A day ago, 2 days ago, we had an organization called Freedom of Religion for South Africa. And one of the points they were making was that we must remove the issue of spiritual abuse as part of the definitions. It's very possible that at the end we might not remove that definition. But I'm making that point to come to you in terms of this request that, you see, when you say you support this subject to us agreeing with everything else you have suggested, it means that everything else that is good about the bills that you might not have commented, when we table this, you will find yourself not supporting it because in the discussion and discourse, we might have come with different approaches and versions to what you were suggesting. So the request is, I think it will leave a bitter taste when you've done so much work and at the end, you leave us with a gun on our heads about having to agree to this, that you will only agree if sihamba nani. Uyaqonda, ndifuna nje loo ndawo nje mhlawumbe ikhona indlela ebenoyibeka ngayo. Thank you, Chair.
Thank you, Honorable Janche. Honorable Nomathemba Maseko Jele.
Thank you, Chairperson. Also, thank you for the EFF for coming and make a presentation, even though after they have given us problem of not indicating that they will be doing Chairperson, they will be coming for oral submission. But we forgive them, Chair. That must not be done next time. ngazi ngoba ngiyabasukela. They will come hard on me, but
I'd like a point of order. I'd like a point of order, Chair, because we did change submissions and
Honorable
okay,
members, honorable members, please. Can we just focus on the presentation?
Okay, Chair, that was on the lighter note, Chairperson.
Let's focus on the presentation. Thank you very much.
Let me welcome their presentations, Chairperson. Also, their support in some of the areas indicated on the bills. But I only have one or two questions, Chair. On this one of saying all women are vulnerable, there is a view that it's not all women above 25 are vulnerable. That's what the presenter said. I wanted just to find out because there's a view that it's not all of them. And those women, they can speak for themselves. They can, when you clap that one with the issue of mandatory report, that those women can, I'm just bringing them in one basket together with that of the issue of mandatory report, that they must go and report for themselves. They must, the issue of mandatory report must not be allowed. People must just be able to have confidence and go and report their matters. But Chair, I want to hear their view, because maybe this might be an issue where we only look at one area of sector of women who can speak for themselves, women who can stand for themselves. But what about those who can't do that? And we know we're coming from the town where we hear every weekend there are women who are really screaming for help in our neighbors, want us to help them. But you find that at the end of the day, tomorrow, they are not prepared to go and report. And there's this part that says there must be allowing people around that woman to go and report. But there are people who feels that no, those women, they must go and there must be no one who help in that situation, Chairperson. I just want to hear their view, though I just mixed issues, but can I hear what is their view on that one? Thank you, Chair.
Thank you very much. There are no further hands. Can I now hand over to the EFF to respond to the issues raised?
All right. Thank you very much. We will be responding to the questions. And I would like to start with the question, I think it's Honorable Janji, on the issue of tightening the bill. What I would like to bring to your attention is that, honorable members, we are in this meeting right now and we are speaking in terms of tightening these bills. But what we need to acknowledge and accept is that these bills, they have not brought the solutions that they were intended to when they were drafted. We had these bills. It can be probably for 20 years, 10 years, or 5 years in South Africa. But now it has not kept the raping of children and the killing of women and the violence against any human being in South Africa. The reason is because why would we tighten a failed bill? We must agree that these bills have failed us as South Africans and is still failing women. Why would we want to take a formula that has failed and we want to tighten it up right now? What should be done? What we should be looking at right now, it's an issue of consulting or in an issue of a method of drafting new bills altogether. I know it might take time. How do we do that? We might have consultative meetings, community meetings, and also go to areas where these issues are happening and where the stats are showing us a number of those issues. And we go and we seek solutions in terms of that. There are so many issues that are happening in South Africa. And what we're failing to understand is the psychology, the mindset of the perpetrators. That how do you go and rape a 3-year-old child? Number one. How do you go and rape an 80-year-old woman? How do you go and kill and stab and burn a woman? In all of this, as much as we've tried to read this bill and find solution as the economic freedom fighters on how we should amend them, they are not speaking in terms of the immediate intervention and immediate responses that we as the government, we should be looking into. So we need serious intervention. These bills, they are there in black and white. When we go to the police, let's say we take the justice system altogether, we start with police. Number one, our police in South Africa, when women go to police station and they want to report cases of gender-based violence, it can be an insult, it can be sexual harassment, it can be rape. Women have spoken so many years that they are facing challenges in the police station. The problem, it might be, honorable members, these police are not trained properly when it comes to dealing with issues of women and children. When they go for police training, they're in those colleges in Hammanskraal or wherever, you find that the system has not done proper programs where they will be trained psychologically, emotionally to deal with such issues. Number two, when we look into our judiciary, 99% of gender-based violence cases in court are not prioritized. Most of these cases people are being given bails. Reason is because it starts from police. Police are not investigating these cases, are not following up on the processes. For instance, I'll make just an example. For instance, we had a case in Orange Farm where a lady was stabbed and killed. We attended the funeral yesterday. May her soul rest in peace. What we find is that when the police came to the crime scene, they just took photos and took her body. They didn't, and then when the family went to wash her body at the mortuary and everything, they didn't even take the clothes that she was wearing during that day when this incident happened. And those clothes are an important factor in catching the perpetrators. And when we are following up the cases in terms of the forensic, the Gauteng Department of Police will tell us that about 8 or 9 police stations in the Gauteng province or in the regions of Gauteng, they only go to one forensic department, which is in Pretoria, and they have a backlog in terms of following up those cases. So that is where, as leaders, we must be able to look that we must go back to the drawing board and sit down and face all of these facts. Now, the NPA, our National Prosecuting Authority, when they go to court, when police are not giving them the necessary evidence and documentation, they are very much quick to say, Your Magistrate, Your Honor, I would like to call for postponement. And it is us as women, as victims and families, to go back and say to them, please, can you follow up on my case? And then those prosecutors are telling us that, no, the police must do their job. We as women in South Africa, we are left alone to come and fight this plight that we are facing. And as Parliament, we feel that you are very much clueless when it comes to dealing with issues that we are facing on a daily basis as women, because right now, women in communities, you have seen it. They are saying enough is enough. Kwanele. You as honorable members, you must be able to say, let's face this thing head on. Let's make immediate intervention right now. Lastly, before I close and give to my other colleagues, I just want to bring this very, very simple scenario, honorable members, is that during the time of COVID-19, the president and the government said now, we must go on lockdown because we are faced with a pandemic. What did the government do? It went and put regulations for us to follow as South Africans in terms of protecting ourselves. We had soldiers, we had police on our streets patrolling each and every day. We had to wear masks. There had to be programs and even adverts on TV for us to wear masks so that they made us understand, wearing a mask is protecting yourself and the other human being next to you. But now, when we are dealing with this, 8 women in South Africa get killed each and every day. About 10 or 11 children in South Africa get raped every day. Why can't we take the scientific approach that we have taken when we were dealing with COVID-19 and deal with it with this issue of women? Because women are dying. If it has not happened to your family, honorable members, you have not lost a loved one, your sister, your child, your cousin, just be grateful because it is happening to ordinary South African. Thank you very much for that. I would open to my other fellow colleagues that will be able to respond to other questions.
Thank you very much, Chair. I'd like to take on the issue of no bail. In as much as we understand that we are in a lawmaking process, and the Constitution doesn't also limit us to violate other rights with others. There's no right that must be prioritized over the other. Now, when we say we do not want sex offenders to get bail, it's because I think the law of South Africa is very much protective towards the perpetrators done to victims or rather survivors. You find that a 3-year-old is raped, or rather a 16-year-old is raped, and she must still come back after opening a case. She must still roam the streets. After a day or two, the perpetrator has been arrested. The perpetrator gets released on bail. She must still find herself in the same space with that perpetrator in the same community because the rights of the perpetrator is more important than the survivors. Now, when we say sex offenders, and we did not speak on just gender-based violence. We are stressing on sex offenders and femicide because those are the issues that we deal with on a day-to-day basis. You cannot be raped today and find your perpetrator on the streets or have to share the same seat in a taxi with the same perpetrator 2 days or 3 days later. And this is what we find. You open a case as a victim and the perpetrator goes and gets bail. You grant them bail and the victim is not even given any form of counseling or whatever. If a perpetrator goes and opens a case, the police station is very casual about that. You find that the prosecutor or whoever the investigating officer that is taking on the case is very casual on issues of sexual offense. And we are very worried on that because firstly, our victims or survivors do not get counseling. They do not get taken through a process of psychological assistance. The police stations don't have that. The courts don't have that. The only thing they are focusing on is the right of a human being, or rather a perpetrator who has a right to bail and to be innocent until proven guilty. Now, the EFF is completely against bail of sexual offenders. And we are stable on that because we have found in 3 months, we have been on cases of gender-based violence, and most of them have been sexual offenses, have been femicide, and those perpetrators continue to get bail and continue to get preference in terms of law And the South African law has never been on the side of victims. And that is why we are saying there must never be bail for sexual offenders, whether they are found guilty or not. Sexual offenders must remain in custody until the trial has been taken, but rather we must also put in account what the victim or the survivor of that incident is going through. I think the law must not be on the side of perpetrators like it has been throughout the time. We must be able to look into what happens to the victim, what happens to the victim as an individual, what happens to a victim as family, what happens to those around the victim. You find victims who are continuously being threatened by perpetrators because they have a right, or rather their rights are more superior than the victim, to roam the streets and be able to threaten them to say, I will deal with you, I will do this, I will do this. That is why at the end of the day, we find cases of sexual offense or gender-based violence being taken off. A perpetrator will threaten a victim gets to a point where they even want to go and take off the case and call off the case because firstly, the process of taking on the case is very slow. And secondly, they find themselves in very vulnerable spaces and find themselves having to share the same space with the perpetrator. And she finds herself not protected enough. She can't even go to the police station. A 3-year-old can't go to a police station and say, but my uncle is consistently and persistently harassing me at home. So we submit and we're very stable on the fact that there must never be bail for sexual offenders. And we're not taking it back. Thank you, Chair.
Chair, just to come in, it's Leanne Mutasia. Just to piggyback on what Commissioner Sharon was saying, also in terms of on allowing bail, the Constitution is not written in stone. There's nothing written in stone. So even if there's a conflict in terms of us saying that we're not going to provide bail anymore to sex offenders, the Constitution can be amended. So I think that is a very weak argument that a whole member of parliament can bring in a space that we are at the moment. So there's no constitutional rights that are going to be violated when we have perpetrators and victims of such horrific crimes every day being subjected to the same thing. The question in regards to our system on parole, on whether orders should be centralized, on who should be responsible, I think as long as we have this ANC government, gender-based violence is never going to be taken serious. I mean, just the other day we were dealing with a case of a guy who has 3 gender-based violence cases in 3 different courts, and none of the courts knew about it, to a point that we had to intervene so the one court could know, and then the bail application had to be abandoned. So I don't know how we could be at this point even asking questions about whether a system should be centralized or not. I mean, it's something that should have happened a very long time ago, and I think it's only an EFF government that is going to take us to where we need to be in terms of eradicating this horrific crimes of gender-based violence. The honourable member who spoke about the societal, that this is a societal challenge, I think that is just generally a cop-out. And we hear this a lot from the ANC because there is no will, absolutely no will to deal with these issues. The ANC is not only just an enabler of gender-based violence, they are also perpetrators, which we have just seen recently in the Commission of Gender Equality report, where they have tortured women and no one has been held accountable for it. I mean, up to today, not one criminal case has been opened, despite a Chapter 9 institution saying that a government has tortured women. So we will keep making excuses and say that it's everyone's responsibility in this entire country to fix gender-based violence cases. Which age group? There's 3-year-olds that get raped. As our DSG said, there's 80-year-olds that are getting raped. There's 21-year-olds. So I'm not sure which country she's talking about and which justice system she's talking about, that she could ask us that question. So maybe she can just clarify on that. And also just clarify, I wasn't sure what she meant about our view. It wasn't clear because she was raising a lot of things. I guess she was just trying to throw shade on our presentation. She wanted our view on something, but I wasn't sure whether it was in relation to which age group, because we are very clear that all women and children should be listed as vulnerable groups. Thank you, Chair.
Chairperson, also add, I want to add to the issue of having repeated offenders who are repeating the same crimes in a country that allows their rights to be prioritized over the people that perpetuate violence towards. I think it needs to be emphasized that we wouldn't be sitting here if we didn't have a problem sitting amongst a country that has a constitution that is well written, a constitution that addresses everything, but nothing is implemented properly and nothing is properly maintained. On the bail issue, the SEPS as it is right now does not even have the capacity to ensure that the bail conditions are being adhered to. They tell us of not having vehicles. They tell us of not being able to get to the crime scene on time. There are actual cases where the police only gets to the crime scene only days after the crime has been committed. And now the capacity of the state to deal with issues of violence has proven to not be there. In fact, we are assisting the state by saying that no bail should be conducted because to maintain that law and order is prevailed has not been sustained at all. Now, I also want to address that you cannot treat gender-based violence as a choir practice. The reaction and the trauma and that victims or survivors of gender-based violence have is not the same. It is also issued out throughout the family and the community in its entirety. So if a 25-year-old that can speak up on their own cases, it doesn't mean that all 25-year-olds can speak up on their own cases. And I think it is very redundant of us to treat cases of gender-based violence as if they are common, whereas they are not. They need to be treated with the difference of cases that they are coming with. So on the issue of the parole system, the victim finds themselves being back in the same community.
Sorry, ma'am. You only have 1 minute. We only have 1 minute left on this matter. If you can round up.
Thank you, Chair. I think in this last minute, I will emphasize that to politicize gender-based violence, seeing the cases that we are reading, not only on the media, but cases we are getting on the ground, but for the ANC to come to this hearing and politicize us being here and trying to solve this issue of women and children being abused, being beaten, being killed on a daily basis is very it's very unconstitutional. That's number one. If you want to adhere to constitution, follow the constitution by leading people correctly and wanting their safety to prevail first. It is very important that we prioritize the safety and security of everyone who is in this country, and we don't prioritize those of criminals. Thank you, Chair.
Thank you very much. Honorable members, I think we must also acknowledge that this is a public hearing. There is still going to be deliberations that are going to take place after we are done with the public hearings, where we are going to politic and do clause by clause. I would plead that the comrades, the members that have raised their hands, the time to entertain this presentation is now over. We will still come back to to all the presentations when we deal with the deliberations. Can we move to the next presentation? Can you allow me to? Honorable members, to move to the next presentation? I know that the last presentation has raised a lot of issues, and I still think that those issues are still going to be raised when we do the deliberations. But the risk that we have now, if we allow members to come back, then there is going to be a right of reply. We might not be able to finish. Please, honorable members.
Great, Chair.
It's okay. Chair. We understand, Chair, that.
Yes.
No, I'm saying, Chair, I support what you are saying, that but we must not entertain it more further due to time constraints. We'll have time to discuss these matters. Just that when you come for a presentation unprepared, you become more emotional and sarcastic. Thank you very much.
Thank you very much, honorable members, for your understanding. Can you go to the Embrace project? Can you go to the Embrace project? EFF, I think if you can take your slides, because I'm not able to see members, and allow the other one to flash their slides, please.
Okay.
Sorry, Honorable Chair, can you see our slide?
Yes, we can see your slides now. Thank you very much. Over to you. You have 20 minutes to make a presentation.
Good morning, members of the Portfolio Committee. My name is Leanne Jamanis, and I will be presenting on behalf of the Embrace Project along with my colleague, Cassandra. I am the director of the Embrace Project. I am an admitted attorney and also a legal researcher into gender-based violence in the criminal justice system. I'm also currently a law clerk at the Constitutional Court. Just to give the committee members a bit of an idea about our organization, we are a non-profit organization which aims to creatively combat gender-based violence. So our organization uniquely marries a very unlikely pair, being art and advocacy. We raise funds for grassroots organizations combating gender-based violence in their communities by selling art on our online platform. We also create awareness around gender-based violence, its causes and its prevalence on our social media platforms. Before I take the committee members through each of our submissions on the 3 gender-based violence bills, I'd just like to actually set a bit of a background and create a bit of a setting for the members. And it actually addresses some of the issues that were raised in the last presentation, some of the questions that were also raised by the committee members. And that actually speaks to the question of preventative measures. What we have noted is that the amendment bills, along with current enacted legislation, only focus on punitive sanctions. So in other words, there's little to no focus on preventative measures. This is particularly important because what it means is that the legal system is only engaged once the harm has been committed. And in many cases, and I'm talking about femicide in particular, that's just too little too late. So what I'd like to do is to create a little bit of an explanatory setting to explain South Africa's culture of violence and the rape culture that we currently have. As we all know, we come from a very checkered past. We come from a past of racial oppression and violence, which started off with colonialism and then progressed into apartheid. And although we are aware of some of the visible remnants of apartheid, which is the inequalities that we still see, there are many things that we don't focus on, possibly because we either don't know about it or because they're not visible to us. And one of those things is, for example, the population's ambivalence towards the law. So because previously laws were used to oppress or discriminate against a majority of the population had an ambivalence towards the law because they rightly felt that the laws were illegitimate. 26 years into democracy hasn't changed that attitude towards the law. There is also an issue that was created by these discriminatory and oppressive systems, which had a monumental effect on the population's sense of self-worth. It lowered the majority's sense of self-worth. That coupled with inequalities which have now become institutionalized, previously on the basis of race and currently on the basis of socioeconomic standing, but obviously founded on previously disadvantaged backgrounds. As South Africans, we have a problem with substance abuse. And in the past, it was used to, and possibly also obviously in the present, it was used to numb the realities of the population. The majority of South Africans live below the poverty line. And they find it hard to change their position because, for one, we have a very high unemployment rate in South Africa, which is only likely to increase with the COVID-19 crisis. We also have very low or poor marketability in the sense that the majority of our labor force is actually unskilled labor. So what ends up happening with all of these factors is that it ends up creating a very dangerous sense of disempowerment among the majority of our population. And as we know, gender-based violence is all about exerting power and control. It is about a perpetrator exerting his dominance or his power over a more vulnerable or a weaker victim, which is why victims are usually women or children. Another thing is that violence is learned behavior. Millions of South African children who grow up in violent households where violence is either perpetrated against them or in front of them are most likely to grow up to be adults who then perpetrate the same cycle. Everything that I have mentioned here is actually included in a report that was produced by the Center for the Study of Violence and Reconciliation. They produced this report in 2017 already for the department, or for the then Department of Safety and Security. They came up with fantastic recommendations, none of which were implemented. So I really ask that the committee members bear this context in mind when questioning why it is that our criminal justice system has not only failed to protect victims, but it actually, in oftentimes, perpetuates the same kind of violence. It's the disempowered South Africans that I've just mentioned that actually make up the criminal justice system. Each of us, every one of us as South Africans, grow up in a culture of violence and in a rape culture. And if we are to ever properly implement such progressive pieces of legislation, we actually have to work on eradicating this culture of violence. And now I will hand over to my colleague Cassandra, who will take us through the rest of the presentation.
Good morning, honorable members. My name is Cassandra. I have a master's degree in the social sciences in development studies, and I am an intern for the Embrace project. I would just like to take the committee through our common recommendations across all three of the amendment bills. The first being implementation or lack thereof, sensitization training, effective accountability mechanisms, and last, which many of the other presentations, as well as some committee members have pointed towards, is preventative measures or lack thereof.
I will now just take the committee through our first written submission, which was to the Sexual Offences Amendment Bill. I'm only going to go through the highlighted key recommendations that we made. The first would be that consent should be clearly defined in the current Amendment Act. It's only described currently in the Amendment Act in Section 1, Subsection 2. And in many sexual offences cases, they turn on the question of consent. We also highlight the fact that coercive circumstances, in other words, circumstances in which victims' consent can never be considered to be voluntarily given, needs to be provided for in the amendment bill and needs to be properly defined. And in respect of those two recommendations, I would point the Portfolio Committee to the South African Law Reform Commission's reports on the Amendment Act before it was enacted, when they were producing the Sexual Offences and Related Matters Amendment Act. The next recommendation that we make is a decriminalization, or at least the legalization of the sale of sex work. If not, also the decriminalization and legalization of the purchase of sex as well. I know that that might not necessarily be palatable to the committee, which is why I'm suggesting that at least the decriminalization and legalization of the sale of sex work be considered. The reason for that is that sex workers are heavily discriminated against in the criminal justice system. There is a widely held view in the South African police services that sex workers can't be raped. So in order to get rid of that social stigma, as well as to ensure that sex workers enjoy and enforce the full ambit of their rights, that their trade no longer be criminalized. The next observation that we made is that the Amendment Act as it currently stands criminalizes the supply, the production, and the possession of child pornography, as well as pornography involving the mentally disabled. But there is a loophole in in this provision or in these provisions. And the reason I say that is because nowadays the majority actually view porn online or subscribe to online porn sites. And that would mean that they're not in possession of child pornography or pornography involving the mentally disabled. So that is a loophole in our law. And the way that I would suggest that the Portfolio Committee deal with the implementation of this kind of a provision is to take from what has already been put into the Domestic Violence Amendment Bill and to transplant that into the Sexual Offences Amendment Bill, where courts are empowered to order electronic communication service providers to give them information on, I guess, in the domestic violence setting on the respondent, and in this setting on the viewers of this kind of prohibited porn. So the service providers can actually provide SAPS or the NPA with the identity as well as the location of a viewer of this kind of porn. In keeping with the theme of technology, we also think that it's extremely important to point out that the Sexual Offences Amendment Bill should also make provision for cybersexual offences. Because as we know, sexual offences nowadays are committed online. They're committed via text, on social media. And so we suggest that those definitions, or at least cybersexual offences, be provided for in the current definitions for sexual offences, or that whole new offences are created. We would also like to suggest an expansion in the definition of vulnerable persons. And I know that this has been a very contentious topic, particularly based on the previous presentation, but we would like to see included in the definition migrants, refugees, asylum seekers, sex workers, the LGBTQAI+ community as well. And I particularly mention migrants, refugees, and asylum seekers because oftentimes they're undocumented. And when you're undocumented, you're invisible to the law. And when you're invisible to the law, you are most susceptible to exploitation, and in particular, sexual exploitation. I would also like to note, and I see that that is something that hasn't been raised yet before this committee, that there's a contradiction between two vulnerable categories in the definition of vulnerable persons. The one category provides for a vulnerable group of only of females of 25 years and under, and then another category provides for a vulnerable group of adults who are 60 years and above. Now that's a contradiction because you put a bar at 25 for females. It's also a nonsensical bar that's been placed. And the reason I say that is that all females are vulnerable. And I know that in the previous presentation, a question was raised about, but 25 years and older, you're able to basically report your own cases. This section has got absolutely nothing to do with the agency of vulnerable persons. It's got nothing to do with their ability to report cases. It's got everything to do with them being a vulnerable category. And this is defined in this part of the amendment bill because you'll see throughout the rest of the amendment bill, there's a reference to vulnerable persons, and it has nothing to do with the laying of cases. The next point that we raise is on the National Sex Offenders Register, or the National Register on Sex Offenders. We note that in the objectives, which are attached to, or which are included in the memorandum to the amendment bill, that it's provided that, or one of the aims is that the National Register be made public. We note that throughout the amendment bill, no such provision has been made. So the recommendation that we would make to the committee is that certain particulars of sexual offences be made publicly available on the website of the Department of Justice and Correctional Services. And in that regard, I refer to the committee to page 5 of our submission, of our written submission, paragraph 15, where we describe exactly what those particulars are that we suggest be made public, so that we look after both the rights of the offenders as well as allow the public to protect themselves. I would also just like to highlight a few stats to the committee. 35.5% of sexual offences are reported to SAPS. Of those reported cases, 40 to 60% of them are withdrawn by either SAPS or the NPA on the basis usually that they're false. Of the reported cases that are not withdrawn, only 8.6% of them see a successful prosecution rate. And that's quite appalling. The issue here for us is that sensitization training and monitoring mechanisms have already been provided for in the current Amendment Act, and that's included in sections 65 and 66. But clearly, based on these statistics, those great provisions are not being implemented, and the Amendment Act has actually been in force since 2007. So we would request that the committee investigate the reasons for the poor implementation. I now hand over to my colleague.
I will take you through our recommendations on the Criminal and Related Matters Amendment Bill. Our first recommendation is that a complainant in a case of domestic violence should be informed of a perpetrator's parole consideration, regardless of the length of time of the sentence. Our next point is that in section 316B, in clause 10, it makes appeals more onerous. Our most important recommendation for this bill would be that we recommend that rape and compelled rape without aggravating circumstances and sexual exploitation should bear a minimum sentence of life imprisonment. Rape in and of itself is an aggravating circumstance already. We do not need other circumstances to justify that someone gets a life imprisonment. And I would just like to point to a quote what was found among South African sexual abusers to point to the severity of rape. So the majority of South African sexual abusers told the UN Special Rapporteur on Violence Against Women that they commit sexual violence out of boredom, for fun, or because they are entitled to. Our own constitutional court described rape as being, as for far too long, rape has been used as a tool to relegate the women of this country to second-class citizens over whom men can exercise their power and control, and in so doing strip them of their rights to equality, human dignity, and bodily integrity. I will now hand over to my colleague.
On our last submission on the last bill, which is the Domestic Violence Amendment Bill, we make 3 recommendations and 1 observation. The first recommendation, or rather the first point that we note, is that the criminal liability imposed for reporting domestic violence, particularly when it comes to functionaries who are psychologists or healthcare workers, may actually result in their work being undermined, because what happens is the trust relationship between functionaries and patients who are then victims of domestic violence will actually break down if the victim feels like one of these functionaries will report their situation. And the committee should bear in mind that sometimes reporting situations results in a worsening of the victim's position. It might also inadvertently result in an increase or an encouragement of a culture of silence and victim isolation, because victims, as well as functionaries and possibly also third-party laypersons who are also required to report incidents of domestic violence, may result in all 3 of those parties distancing themselves from one another, either to avoid criminal sanction or to avoid having their situation reported if you are the victim. And these are the negative consequences of those provisions that the committee may not have actually picked up on. Another recommendation we make is that special rules should actually be developed for witnesses and complainants in domestic violence cases. And in respect of that, we point the Portfolio Committee to the International Criminal Court's rules on procedure and evidence for victims of sexual violence, and in particular, Rule 72. In that aspect, in order to also just further explain the rule, I would refer to the committee members to page 7 of our written submission on the Sexual Offences Amendment Bill, not the domestic violence one, at paragraph 21, which properly sets out the rule. The last recommendation we make is that the respondents should always be liable for costs occasioned by any proceedings or orders handed down in terms of the Domestic Violence Amendment Bill, and it should never be the complainant. We note that Section 18 of the current Act provides for policy development and accountability mechanisms for SAPS in the NPA, but this has been enacted since 1999, and clearly they're quite ineffective then. So we would recommend that provision also be made for public education campaigns around accountability mechanisms to empower the public to report complaints. And obviously there should be a push for more sensitization training and a proper implementation of that.
You have 2 minutes left.
Thank you, Chair.
Thank you. In conclusion, we would just like to make recommendations which are across all three of our recommendations for all three of the amendment bills. The first is rehabilitation programs for both sex offenders as well as other offenders of GBV and femicide, and an overhaul of correctional services facilities so that they do not release unrehabilitated perpetrators.
We would like to stress once again the importance of compulsory and regular sensitization training for the entire criminal justice system. And for that, I would just like to make 2 examples available to the Portfolio Committee of instances where that wasn't the case in the highest levels of the criminal justice system, being the judiciary. The first is in November 2019, a KwaZulu-Natal magistrate sentenced a father who she had convicted of having raped his 11-year-old daughter to a wholly suspended sentence of 5 years, because she decided that the rape accused was a good father. In September 2018, in Zamla versus the state, a Western Cape High Court judge found in mitigation in the sentencing of a rape accused who had repeatedly raped a child that the accused had had a history of prior consensual sexual intercourse with the victim, who was 13 years old, who could never have consensual sexual intercourse. He also said that there was no actual violence used other than forced sexual intercourse, and that the accused stopped his assault when the victim started bleeding, thereby showing mercy. These are the reasons that the learned judge decided that the accused should actually have a reduced sentence for.
And then secondly, talking back to preventative measures, we recommend public education campaigns which are required to dispel harmful myths, practices, attitudes, and behaviors and stereotypes, as well as specialized school curricula.
And lastly, once again, we reinforce the point that the law of evidence should be reformed in this country to be more victim-centric. And again, we would refer the Portfolio Committee to the International Criminal Court's Rules of Procedure and Evidence for Victims of Sexual Violence. Thank you very much.
Thank you very much to Embrace Project. I will now note hands from members who would want to interact with the presentation. I have Honorable Kolangola, Honorable Vernahon, Honorable Nivot Trahan. I must note that there is no social distance between the two of you, no masks, no sanitization. It's a point of concern when we deal with the underpandemic. Thank you. Thank you. Honorable Kolangola. Honorable Ngola. Honorable Vernahon.
Yeah, thank you, Chairperson, and thank you for the presentation. I want to firstly touch base on the references to rehabilitation and sensitization projects in the presentation. And I want to hear from the presenters. I think, firstly, I want to make the statement that these are obviously policy issues, but I want to hear from them. At what point do we as a country start considering that, given the severe impact of gender-based and sexual violence, that we should go as far as include some of these policy considerations in legislation? So we now sit with 3 amendments aimed at strengthening the legislative framework, but if we agree, and we for one do with them, that a stronger focus has also to be placed on rehabilitation and sensitization. At what point, if there is failure or a continued failure to properly address these, should the legislature consider including that in legislation? And then secondly, in respect of the comments made regarding the law of evidence, Chair, I would want to suggest that possibly we should ask them to follow up this presentation with a more detailed presentation as to how they see this unfolding. But once again, one must consider that it would not necessarily be wise in criminal legislation to include matters of evidence, whilst what they are saying, I think we need to think carefully about this, and I would like to hear their views whether it would be proper to include it in legislations dealing with offences, or rather to include it in either rulemaking or separate legislation. Thank you, Chair.
Thank you very much. Honorable Nieuwoudt Dragens.
Good morning, Chair, and good morning to everybody on the platform. Thank you to the Embrace Project for your presentation today. On the one hand, sorry, if you could just give me a second. So on the one hand, we can have the best legislation, pass the most progressive legislation. That's on the one hand. However, on the other hand, you said the cycle of violence. You refer to the cycle of violence. So I am a social worker by profession. So the cycle of violence must be broken and can only be broken through intervention or intervening with the cycle. So the cycle of violence, which children grow up seeing, and then as adults themselves perpetuate the violence unless there is an intervention to break that cycle. So with that in mind, research shows that sexual violence is perpetrated by people that the child or that the victims know. So they know the person in the home or from the community. We can't police the home, inside the home. There are many organizations who are against government, interfering in the home. And knowing this then, what I've now presented, how, we can have the best laws, but the cycle of violence, like you're saying, can continue. So where must we do? What must we do given these two circumstances? And of course, it's not only about, the violence is affected by other, alcohol abuse, substance abuse, etc. And, for example, people socialize in a bar or something, get drunk, and then the violence happens. So where does the law have to get tightened given this kind of circumstance? And then secondly, gender-based violence is terribly on the increase, and you have mentioned online circumstances of gender-based violence. And in that regard, you said 9.6% of cases that do go through with a successful conviction. And, we know the reasons about the police and, why the cases don't go through. The prosecutors say there's not enough evidence, and, other women themselves or other victims themselves withdraw the cases. So in your view, what can we do to ensure that the cases that come before the police service do eventually go through the entire justice system all the way to a conviction? And then you mentioned rehabilitation. What I'd like to ask is that rehabilitation by so when the judge gives, or the judge or the magistrate hands down the conviction, must rehabilitation be part of that conviction, made compulsory? Because rehabilitation can be voluntary. I mean, organizations like AA is voluntary. Only if I want to be rehabilitated. So I'm asking then, do you think that rehabilitation should be made compulsory for all perpetrators or all cases of gender-based violence? Thank you very much, Chair.
Thank you very much. Honorable Ngola, are you back?
Yes, Chair, I'm back.
Okay.
I am covered though.
You are covered. No, thank you very much.
Yes,
one issue I would just want to bring to attention. The cases you have mentioned by both the magistrates and by the judge, I think as NGOs, I think it would be also important where there is, in your view, a gross miscarriage of justice, that you bring such to the attention of the Magistrates Commission with respect to magistrate and to the JSE with respect to judges, because some of these victims might not have the resources that you might have as NGOs. That also, I mean, talks to organizations like your Chapter 9 institutions, but we have to bring these issues to the attention of the relevant authorities, because that would also assist to ensure that such presiding officers account to their peers for some of the judgments that they make, and it can also assist in the readjustment of the curriculum, as it was mentioned yesterday and day before by Honorable Mfokeng, that there needs to be specialization on issues of gender-based violence, not only for police. I think it's quite clear now that also everybody, including the judicial officers, that we would need to have such a specialization. Over to you.
Thank you very much for all those questions. They are really great questions. Honourable Chair, I think I will probably just address your statement first. You mentioned reporting these incidents to the Magistrates Commission and the JSC, otherwise known as the Judicial Service Commission. So for the first case that I mentioned in respect of the KwaZulu-Natal magistrate, she actually handed down a very a large number of judgments, I think about 6 that they counted, which are an absolute miscarriage of justice. I only mentioned one. It took the Magistrates Commission, I think, a year after her matter was reported to them, for them merely to suspend her pending investigations. So she was still sitting on the bench, even after the matters were reported to the Magistrates Commission. And the only reason that she was actually suspended in the end was because of the media coverage around her appalling judgments. So that's the one concern, is the teeth behind these judicial accountability mechanisms. The other mentioned accountability mechanism being the Judicial Service Commission. I'm not going to speak in my capacity as a law clerk of the Constitutional Court. I'm speaking in my capacity as director of the Embrace Project, but that commission clearly also has no teeth. And I think we can all think of a particular Western Cape High Court judge who has circumvented the jaws of justice for the last at least 12 years through the JSC. To then address the questions from the other members, Mr. Horn, he raised the questions on sensitization training and rehabilitation programs, pointing out that there are policy considerations and not necessarily legislative considerations, or they shouldn't be translated into legislative provisions. So to answer that question on whether or not it should be included in legislative provisions, it's quite a simple answer. And the answer is it already has been. So in my presentation, I referred to sections 65 and 66 of the Criminal Law brackets Sexual Offences and Related Matters Amendment Act. So already in those provisions, and I can read them out to you if you would like, there are quite detailed provisions on sensitization training or policy that needs to be developed by both the NPA and SAPS. And there is also accountability mechanisms included in there, which actually involves Parliament and having to report to Parliament. So that's in one of the bills. And another bill that also includes some of this sensitization training is the Domestic Violence Act as it currently stands. So in as much as they may be considered policy considerations, they are already included as provisions in current legislation. So I see no reason why we shouldn't go ahead and make those provisions either clearer or more detailed or include more of those kinds of provisions in other pieces of legislation. Then the question on the law of evidence, I will also, at the end, give my colleague an opportunity to respond to the questions also raised. So on the question of the law of evidence and the request that we follow up with a bit more of a detailed presentation on how to reform the law of evidence, I think the question there was, would it be proper to deal with the reform of the law of evidence in offence legislation, in separate legislation, or in rulemaking? I think probably the most appropriate manner of dealing with that kind of reform would possibly be to enact an entirely new piece of legislation on the law of evidence. Because the law of evidence is quite extensive, the Portfolio Committee might not want to just restrict itself to reforming the law when it comes to sexual offences and how victims are dealt with and how non-victim centric the law of evidence is there. There is a very interesting history behind the law of evidence. The fact that in Roman Dutch law, in order to successfully convict somebody of rape, one of the requirements was that immediately after the rape, the victim had to run down the street screaming. There was also a cautionary rule in South African law, which said that basically victims of sexual offences, particularly rape, had to be dealt with circumspect because they were often women, and women had a propensity, I think, quote, to lie and deceive. And you'll note in section 60 of the Sexual Offences and Related Matters Amendment Act, there is an abolishment of that cautionary rule. But unfortunately, the cautionary approach is still applied even in our judicial system, let alone SAPS. The next question was on the question of, this was raised by another member, the question of progressive legislation versus the cycle of violence. That we are basically suggesting that although we have progressive legislation, the cycle of violence won't allow for that kind of progressive legislation to be properly implemented or to be effective anyway. And that what we need is interventions in order to break that cycle. She also mentioned that predominantly in South Africa, there are cases of what is called acquaintance violence, which is violence perpetrated by someone you know. So the question here was, the statement made here was that we can't police what happens at home. That is absolutely true. So what we recommend is that because we can't really change what happens directly in the household, we have made recommendations to even the Department of Social Development on the current Victim Support Services Bill on things such as introducing school curricula, which is very specialized towards breaking down stereotypes around gender-based violence, negative attitudes, practices, and understanding that is...
Sorry, we are left with... Hello? We are left with 2 minutes to conclude.
Okay, then I'll just wrap that up. So we make those recommendations, and then I would also suggest that the committee referred to the recommendations made by the Centre for Violence and Reconciliation. They recommended psychosocial services into violence-prone communities those kind of interventions. Then the last two questions, the one was on what can we do to ensure that reported cases go through the entire process, and that is to ensure that there is some sort of a relationship between existing victim support services and SAPS to ensure that it's a smooth process for victims. And I also think that the Victim Support Services Bill, when enacted, will assist in basically making it compulsory for the criminal justice system to report back to victims on the status and progress of their case. So the question of obviously resource constraints are always the problem cited by particularly the NPA and SAPS, that they're short on finances and human resources. So that is a budget issue that the government would have to resolve. Then the last question was, should magistrates and judges impose compulsory rehabilitation? They have within their discretion the ability to impose rehabilitation orders. And what we're trying to say beyond that, the Correctional Services Department, or rather the Correctional Services System, should have that already available in it. So it shouldn't just be a matter of locking up perpetrators so that you don't release them into society, because eventually they will be released into society, but most likely as more violent, given the nature of violence in correctional services facilities. Thank you. Thank you, Chair.
Thank you, Chair.
Chair, can you hear us?
Thank you very much. Thank you very much for the presentations. We have members of the Judicial Services Commission here with us, myself and Honorable Glenis Breitenbach. We have members of the Magistrates Commission, Honorable Janche, Honorable Horn. We have taken note of the issues you have raised. Thank you very much for the presentation. It will be considered with other presentations when we deliberate on the bill. Thank you very much. Honorable members, the next organization is WISE for Africa. Is WISE for Africa in?
Yes, we're on, Chair.
Oh, thank you very much.
We sent a presentation to SM Tonjeni, so we're waiting for her to place it on the screen.
Okay. As we are waiting for Mr. Mtonjeni to fly,
be. It's by one of the components that we bring in to ensure that we address the violence that is meted out against women and LGBTQI, gender non-conforming, and all the vulnerable groups. But what is important for us to note is these bills must be properly funded, because we are not going to have these bills being operationalized and there's no money being made available to ensure that they are executed and implemented effectively, right? So there has to be resources made available for that to happen. Precisely, Chair, because if we do not have adequate funding towards the changes that we wish to introduce in these 3 bills, then we are dead in the water. It's not worth even the time that we have spent here today to try and make sure that we strengthen our laws. Because if we don't have the necessary resources, whether it's human resource or financial, to ensure that we implement these bills, it's wasted time and effort. So I'm going to then give over to my colleague, Onika Makwakwa, to deal with the first two bills.
Great. Thank you very much, Brenda. As Brenda has already mentioned, what I'm going to deal with basically is the highlights of what we have submitted in writing to the committee. And most of this really deals mainly with attempting to strengthen some of the provisions that are here to make sure that we have the kind of implementation that will give us the outcome that we are looking for, but also consequence management for failure to implement, which then brings up the issue of funding and resourcing these laws to make sure that they truly benefit women. The first one is Section 51A in the Criminal and Related Matters Bill, and that is the provision around intermediaries for providing evidence. It's not very clear in the proposed amendments what the criteria would be for even selecting these intermediaries. We are therefore recommending that a panel be put in place for vetting the intermediaries before they are fully appointed. We see that the appointment would be done by a magistrate, but the vetting needs to be very clear that we have a panel that's responsible for this role. Also, this provides for closed circuit, being able to use a multimedia platform to provide evidence and to testify. We certainly welcome this, and I think especially now with COVID-19 experience, we see the value of being able to continue with some of these hearings. But we really think that there should be some provision that makes sure that we use a technical capacity similar to invigilation to make sure that the person giving evidence on the other side is not being coached or is not being given text to read from. That way we know fully that this is their true testimony. The next item under criminal and related is section number 2, section 59, which really looks at consequence management. There's a lot of provisions on the bill that don't necessarily state what would happen if an official fails to implement as recommended. The bail application process at the police station level has been abused historically in this country. And we want to make sure that, while it's a convenience even for the victims and survivors to be able to deal with some of the matters at the police station level, the bail application in particular has been abused by perpetrators. And we want to make sure that there is some consequence management in the bill that ensures that we deal with the police who do such, and even prosecutors sometimes who collaborate in being able to make things easier for perpetrators instead of them facing the full extent of the law. We understand that perpetrators have a right to bail, but we believe that, similar to what the president has stated, that the state must always seek to oppose bail. We are not seeing this on a consistent basis. And the burden of that needs to be at the prosecutor's level to make sure that they are constantly showing up and opposing bail as supposed to. And that's the stringent conditions for people who are out on bail, including checking in on a regular basis at the police station, as well as psychotherapy and anger management, because a lot happens in between the time they're out on bail and when the case actually goes for hearing, that actually puts women in even further danger. I'm going to move on to the next slide, number 7, which is still also on bail, but and particularly number 8 on disarming police specifically, who have protection orders that have been issued against them. I know that there's been quite a bit of resistance of this, but we've got actually a really sorrowful example in this country just a year ago, where a female boxer was murdered by her partner, who was a police officer with a service pistol, and she had a protection order against him. So not just that one example, but we believe that people who have protection orders against them should be disarmed, should not be able to apply for a firearm during that period. And that restrictions should also apply to police as well. So disarming police and blocking applications of gun licensing is really important during that time. On to this criminal law, sexual offenses and related matters. The first one, I think several groups have mentioned this, that the persons who are vulnerable definition leaves out women ages 26 and 59. And I'm not sure if you've looked at the statistics, I'm sure all of us have, at the statistics of who is mostly targeted. And I think we will all agree that it's actually a huge oversight to not include women ages 26 to 59 into the groups of people who are potentially vulnerable for sexual offenses. In addition, the amendment is mute on LGBTQI plus community, and we know that they are particularly targeted in what is known as corrective rape in these sexual offenses as well. So it's really important that we capture that. The other aspect that's not captured is women's economic vulnerability, women who are economically vulnerable. And I'm thinking here mostly about domestic workers, for example, where they are abused at work even, that their vulnerability is particularly also influenced by the fact that they are financially at a disadvantage to whoever the perpetrator may be. The next part deals with the registry. We completely support the expansion and welcome the expansion of the sex offenders registry. We have given some examples in our submission on how other jurisdictions have actually dealt with the kinds of detail that you provide, that should be provided. The sex offenders registry is not just about employment, but it's also about our communities and us being able to protect our children and women in our communities. So it's really important that it is implemented in a way that is fair, that is also informative and valuable. It needs to be searchable. Perhaps an opportunity for us to use our technology classes to assist us in really having a good, strong, and effective sex offenders registry. We believe, though, that they should also include an image of the perpetrator. The information that is provided is fine, but including an image is really important. All perpetrators, if they've been arrested, have a mugshot at minimum. So we believe that an image should also be included in this. The next one deals with the removal, how people get removed from the sex offenders registry. And it's quite inconsistent in terms of, some get removed after 20 years, after 14 years. Rape, unfortunately, worse or any better just because you're a child, an adult, whatever. It is an assault to human dignity, period. And therefore, we believe that a 20-year term should be consistent across all types of sex offense. and not this 5-year, 14-year, whatever, but also because one of the things that we know we struggle with in this country is implementation, monitoring, and consequence management. Having these be a uniform term would make it easier so that no one is able to pay anyone to make sure that they can be removed at an earlier date than not. Everyone needs to have a consistent 20-year term to live with this. And I think it also sends a message that we are serious about GBV, and we are serious about ending and discouraging potential perpetrators from engaging in such behavior. The next one, section 54 on obligation to report sexual offenses. We actually do support this, but we want the amendment to actually identify these professions. We gave an example in our submission. For example, in one jurisdiction overseas, teachers are obligated to report knowledge of sexual abuse, especially of children. They are given adequate training in order to be able to do so. That requirement is tied to their teaching license, so that every 2 years when they renew their license, they have to also subject themselves to training on identifying potential sexual abuse and having the responsibility of reporting, not just at school, but also in their communities as well, as an extension of their duty of care and duty of service. I'm going to stop there and switch over to Brenda to talk to us about the domestic violence bill.
Thanks, Onika.
Advocate Madumisa, I must indicate that you have 4 minutes.
All right, thank you. I think what is important is how do we restore trust of citizens with the police? They're the first responders, and how do we make sure that there is that trust that is maintained? We are pushing for installations of CCTV cameras in the police stations, and we want to have body cameras on the police, because what has happened in most instances is that when we complained against the conduct of the police, the suppression and the evidence that is available is not there, and we don't seem to know what is going on at a particular police station. We also want to impress upon the committee to look at interim safety orders that should be issued by the police on the spot once I report a domestic violence matter, and you can issue an interim safety order immediately and remove the perpetrator from the home. And we also want to ensure that and in fact, let me just go back quickly to what Onika touched on the bail. Our position is quite clear. We are firm on if bail has to be denied completely on all sexual offenses, that's our first preference. We want to, quickly, Chair, is to make sure that you include stalking and online violence, because it's missing in the bill currently, right? And in all of this, what we have to ensure is that the current bill that is before social development on victim support must talk to the domestic violence bill so there has to be synergy with that bill and the domestic violence bill, because what is happening at the moment, Chair, is that when the Bill of Rights and the rights that are given to citizens and the right to safety is not being realized, we now run the risk, and that's where we are now, because we actually taking on the negligence of the police in failing to execute their responsibility in terms of their own management protocols. We've got 2 cases. One is going to the Constitutional Court. The other one is going to the High Court, where we are now suing the police for failure to act when they were supposed to act in terms of their own protocols. So it's important that we as a state, we do not say these things and fail to execute because of our own ineptness in how we respond to things. We also check catcalling. It's a serious issue for women in this country. It has to be included into the domestic violence. Lastly, spiritual abuse is a reality for many South Africans. We've got two matters that we're dealing with the Alleluia Ministries, Alf Lukau, the violence that has coming out of that church. We're pursuing them criminally and civilly. So it's a reality. It has to be included in the domestic violence, into the domestic violence, because all these charismatic churches it's a ground for sexual violations. It's happening at a very oh, I don't know what's happening. So I'll stop there, Chair, because
Honorable Lay, can you switch off your, can you mute yourself? Thank you very much. Advocate Matumisa, your time is up. If you can, I'll give you 1 second to round up.
So in a nutshell, Chair, is that, and I want to emphasize the point that we're supportive of these three bills because we understand what is it that we are trying to achieve with these amendments, right? They are not the answers to us stemming violence, gender-based violence in this country, but it's part of the entire ecosystem that we have put in to resolve and find solutions in how we stop violence in this country.
Thank you very much. Thank you very much, Advocate Matumisa and your colleague. I will now note hands for questions. I have the following members who would want to ask questions. Honorable Kolangola, Honorable Werner Horn, Honorable Jakim Fukeng, Honorable Nibot Drachen, in that order.
Chair, Swart as well, please.
Honorable Steve Swart. Honorable Kobutile Janji will be the last one. So after Honorable Nibot Drachen, it will be Honorable Steve Swart and then Honorable Kobutile Janji. Honorable Kolangola, can you start? Honorable Kolangola? Honorable Werner Horn, can you proceed?
Yeah, thank you, Chair. Thank you for the presentation. And I don't want to speak on behalf of the committee, but I want to assure the presenters that I don't think we as the committee have seen, or as a parliament have seen, these bills or the legislative framework in itself as the answer to gender-based violence. So I think we are in agreement with them that this is a more complex issue that calls for a more integrated approach. Chair, I want to again ask the question in respect of their support for a total prohibition on giving bail to anybody arrested for gender-based violence-related offense. Whether in their view such a wholesale ban or prohibition could be justified in light of the presumption of innocence also contained in our Bill of Rights, as well as the fact that our law as developed deals in a very specific manner with bail, and that this possibly could infringe unduly on the rights of those so arrested. And in raising this issue, I want to maybe also ask them specifically whether they think in any event, even if we as the legislature consider this, whether it would be justified, given that the fact that gender-based violence and sexual violence specifically takes place on what you can call a continuum. And in saying that, I'm not belittling the trauma and the experiences of victims for offenses less severe than rape. But the fact is, we as the legislature can't close our eyes for the fact that that whilst all sexual and gender-based violence are unacceptable, that there is definitely degrees of violence and degrees of violation taking place, and how would we be justified ultimately in not taking that into consideration when we specifically make laws dealing with the whole issue of whether bail should be afforded to those arrested? Thank you, Chair.
Thank you. Honorable Mfukeng.
Thank you very much, Chair. Thanks for the presentation from Wise for Africa. Chair, maybe I should declare that during the summit, I was there with Advocate Brenda and with the team that went to do the media statement after that. And I can say that what is happening today with the gender-based violence bills, this is the team that actually drove this matter, and they were among the total shutdown. And for that, we must commend you that you were in the forefront. I want to also say that you made us to remember that the national strategic plan is there, as we were discussing, and none of the people that came to do the submissions actually looked at the national strategic plan, because it's people who were sitting there to make sure that things happen. But now I want to check on the resources. The budget that is there, that is set to be 1.6 billion. Do you think this budget is going to be enough? One. Number two, on the consequence management, I'm glad that you raised that. What do you suggest? Who should do the oversight over that? Because we do have the police with their own matters, IPT is dealing with issues, we have the Chapter 9 institutions, so we should be able to help when it goes to implementation. What are we saying? Because most of the things that you are raising, you were so clear, because when you raised an issue, you were also coming up with an implementation sort of solution. That is welcome. And Chair, I think we should note that it happened on this. They're also on how do we restore trust. They came with an implementation solution, which is something that we need to discuss on the CCTV cameras and going forward. But now I want to check on the issue of training. You spoke more about the police training, and we were speaking about the same thing to say that it's high time that we go for specialization. What about the prosecutors and magistrates? Because there are also many things that are happening there. One wants to also go to the last part to really say thank you, because you have noted the spiritual abuse. It has been a thorny issue, especially with also for SA for Africa, whatever, freedom for religion. But now the last one, Advocate Madumisa, especially for you, on the current legislation, I'm not leaving you out, Onika, the issue of economic abuse, why it never played a part in the courts? Because we have women that are suffering, and we have so many challenges. Today we see New Zealand having a legislation of having 10 days of pay or whatever leave, and it's actually a grant. Where are we? And I'm raising this because you are still part of the steering committee, and one is getting sober to be understanding that things that were raised in that summit, that was a big summit for everybody, they are coming into play. But also you are very clear when it comes to the register, that is 20 years that you are actually advocating. And others are saying that there are issues with it, and I think you have noticed that. But this is something to be discussed. But thanks very much, Chairperson.
Thank you very much. Honorable Nieuwhout Drachen.
Thank you very much, Chairperson, and thank you for the presentation. Thank you. And then just checking my notes. For a moment, I was lost because the screen was changed. Okay, yes, the register. I would like to ask, many of other presenters before you said that they would prefer an integrated register with the current two that we have. The SABS register for all the crimes, which is more effective, which would be preferable to amalgamate that into one to save resources, and so that we don't waste resources and prevent silo mentality kind of work. So I would like to hear your view on the register to make it into one, so that all crimes are there and it's accessible in that way. Then I forgot one more question, but Chair, maybe it's not for the presenters, but I would like to mention I got a message that somebody said that the National Strategic Plan on Gender-Based Violence and Femicide doesn't mention, is not referred to in any of the bills. So I would just like to plead, when we deliberate on these bills, that the Department of Justice makes reference to the National Strategic Plan. There's also no mention of the Council of Gender-Based Violence, which is now advertised. So maybe something on that needs to be included in one of the three, or in the three bills. There was one more question, but unfortunately, oh yes, no, it didn't slip my mind, but it got back now. I see in the presentation you say that the Tutuzela care centers should be mentioned in the bills. Can you elaborate more on that and why you want the TCCs to be mentioned in the bills? Thank you, Chair.
Thank you very much. Honorable Stephen Swart.
Thank you, Chair, and thank you to the presenters. I appreciate the submission, but I would like to just take issue with the one issue most. I think the issue of the churches is important, and you did raise a matter that you're investigating. I must object to your statement that all charismatic churches are breeding grounds for presumably abuse. I think there are obviously rotten apples, and you correctly pointed out that you are using existing avenues to pursue matters, and I would support that entirely. But I do not think that all churches are guilty of that, all charismatic churches. I think you need to rephrase that, because it detracts from the very good submission that you've made, which we will take to heart. But separately, I'd like to just ask you on the issue you raised, the issues of implementation. And so we could pass a very good amended bills with your submissions as well. But the challenge comes with implementation, and you have raised some of the challenges around that. But we also received a submission from South African Police Services, which many of the members felt was quite disappointing. And I'd like you to comment on how we can further improve oversight from us as members of Parliament when it comes to implementation. I'm sure you'll agree that that is a critical issue. The next issue I'd like you to touch on is the obligation to report domestic violence, which, whilst that is a very positive issue, but when it comes to victims in the domestic violence environment, I think then it can be a challenge, because you could find that the victim then might be prejudiced or have secondary victim trauma when they are obliged, as opposed to where they have a choice or not. And it's a very sensitive issue, because we know there's pressure often placed on victims of gender violence not to report. But there has been some submissions made that maybe one shouldn't make it an obligation that covers the people in a relationship, that then places, if they don't report it, they then can be charged, which might be a bit of an overreach. But thank you for your presentation.
Thank you very much, Honorable Swart. Honorable Kubutile Chanche.
Enkosi Sihlalo. Masibulele ku-Wise for Africa. Thank you very much for a comprehensive presentation with very clear recommendation. One appreciates that because we're going to be applying our mind as lawmakers here for each and every submission that we have received. And therefore, just going through and listening to your presentation, It's very clear that you have taken time to do this, but it's clear that it's also informed by what we call in NGO speak a call face experience. So that's really appreciated. I think you, in your introduction, you assisted me because you started with an issue that we have been raising, and I've particularly been consistent about it with everybody else. That question that says, besides the laws that we must make as lawmakers, that's our role. There are deeper problems in society. And some of those problems, the laws might not. And you've just started with that when we said laws on their own are not an answer and are not panacea of all ills, as it was for zonke. I'm very happy with that. And perhaps the point you raise around those pillars of the strategic plan, because the issue of the laws forms part of other pillars, but the issue of prevention is where my interest is. The issue of prevention beyond any laws, because the issue here, Wise for Africa, if I may make this point, is that part of the problem why we have this scourge in this country is that we'll continue to have this unless we get to the ultimate solution. The ultimate solution is the emancipation of women and dealing with issues of patriarchy in this country. Obviously, that's a long road. There are certain things that we must deal with immediately. So as part of the presentation, if you can comment or follow that in writing, what I have been missing in the other presentation is what one calls the mobilization agenda. Because the mobilization agenda, says Brenda, can't just be about what government must do, what lawmakers must do, what laws we must make. The mobilization agenda has to deal with many of those societal problems. If you take 2019 in PE, when you had a Motoso case, serious human trafficking and issues of sexual abuse, the picture you saw there is that here were mothers of the victims, and yet you had other mothers who were standing with Omotoso. Now, there's no law that can deal with that. Something much deeper. And I would, perhaps not for today, because I think the chair will quickly get me off the platform. Perhaps not for today, but that issue of that mobilization agenda beyond issues of money or resources, beyond issues of the law, but to get into the psyche of society, because this is for me the biggest issue. And as an NGO, I understand that to be your space. The second issue I want to raise is in relation to the training that you have raised, and you have emphasized on the police. As the chair mentioned us, I'm part of the Magistrate Commission. In the next 2 weeks, we have a planning session to begin to interrogate what we call systemic issues in the Magistrate Commission, because there are systemic problems in the Magistrate Commission. Because if we continue in Parliament, continue to suspend magistrate all the time, even on issues of them not applying their mind on the law, it suggests that there's something much deeper. I would, in writing perhaps, so that we don't waste the time of the meeting, because the question I was going to ask you is, what are these key elements of training that you think are missing? And because you have said there's been so much training, so what is missing? Because I know, for example, SAJE, South African Judicial Education Institution, is training many of these magistrates, including a module on gender-based violence. And so it will be important that you share, perhaps in writing with us as a committee. Especially, I would be more interested as a member in the Magistrate Commission to get that, because I think one magistrate said to me that the issue goes beyond just the training, also goes beyond just laws being there. It also has to do with an attitude and a mindset, whether it's the police or whether it's a magistrate. And so I think it would be good if you share that. And lastly, perhaps second last, I'm interested in the panel that you have raised, the panel with civil society in the criminal related amendment bills. I'm curious about that. And perhaps if you can elaborate more on that, and what are you thinking about? What elements of that, and perhaps how you think that could be done, and so on. If it's too much, again, something that you can share in writing. Otherwise, I think those are the few comments I wanted to make, Chair. Thank you very much.
No, thank you very much. Honorable members, even before questions, we are 8 minutes above time. I would not want to censor anybody because it's your right to speak. But when 5 o'clock time comes, let the chair not be under pressure, because it's the chair, is not the chair that is speaking. If we have to be here beyond 5, it would be the choice that you would have made. I just have one question that I think Wise for Africa would need to clarify. When you talk about the vetting of the intermediaries, usually a vetting certificate would have a time frame. People like Honorable Mfokeng, they would know that if you have been vetted for top secret in the intelligence, it's valid for 5 years. So this vetting, how long should it be valid for? Because you can pass vetting this year and commit a crime that would disqualify you in the next 2 years or so. So how long should it be valid for? Over to you, Honorable Madumisa and your team.
Thank you, Chair. We will, and I'm quite grateful to Honorable Member Janchi. We will, in writing, we will submit in writing the following: mobilization agenda, the key elements of training, and maybe also our views further, amplify our views on the panel with civil society that we are proposing, and the vetting of the intermediaries. Because for us, and I mean, it comes from when we made the 24 demands out of the total shutdown. One of the key demands from the total shutdown was that no one who has got a history of criminal sexual offense should be in the civil service and providing a service to the public. And we did not have a time that we had set out. So if you give us an opportunity, Chair, we will then give you in writing our view in terms of how your vetting certificate, how long should it be in operation, if any. Let me quickly deal with the resources, and Onika will deal with the consequence management and touch briefly on the training of the police and the prosecutors and magistrates, right? The resources, if you look at the strategic plan, the costing of that strategic plan is at 8 billion over the 5 years, right? And it's money that has not been allocated, but here we are, we have 3 bills that are very key in the work that you do on a daily basis. And unless that money is made available, we are going to have challenges, right? The 1.6 billion, Honorable Member Mfokeng, that was the money that was announced by the president to allow departments to reprioritize and focus in certain areas in terms of the emergency response action plan. And I would recommend that members of the committee have sight of that report and request that departments account for how that 1.6 was expended, because that's a separate, that 1.6 was specific for 6 months for quick interventions for different departments. These 3 bills are part of that 1.6 from my understanding. Department of Justice decided that one of the key things that they will do as an emergency is to start to look at amendments of certain laws, and the 3 bills are part of that. So that's that 1.6. But the entire strategic plan, the costing for it is 8 billion over 5 years. Honorable Member Swart, I take the point that yes, not all charismatic churches have got the same problems. In my work, the sample that I'm using is just too many that we are confronted with, and I take the point, and I will yield to that. But it's that on a daily basis we are confronted with cases of sexual assault and violation coming from many of these churches. And on the training of the police, prosecutors, and magistrates. So let's, Honorable Janchi, you touched on attitudes and just you as an individual, when you take up a position, what does it mean to you to say, I'm a police officer and I'm here to serve? What does it mean to you as a prosecutor when you walk into a court? It should make you proud that you have applied your mind on your case and you want to win it. And that's what we are missing, because when you look into the court system and you sit in a court and you see how prosecutors have just been presented with a docket and they've got no clue what is in that docket, and they have to stand up before a magistrate and argue and defend, and they don't have it in them to do so. It for me is, what kind of individuals are we attracting into these professions and into the state to serve the citizens with pride and with dignity? And that is missing, and it's something that we have to, all of us have to work on and towards, to ensure that I, on a daily basis, I am driven by producing results and being successful in my work. And just for the police and the magistrates and the prosecutors to take pride in their work on a daily basis. So yes, there's one thing that we also need to appreciate, that gender-based violence is not a straight line. Completely, it's not a straight line. And unless you understand that as a prosecutor or a magistrate or even the police, when a matter is reported to you of assault, that assault itself is loaded, because when you start to strip it and unpack it, you'll find layers of other things coming up. And you require a magistrate and a prosecutor who's able to peel the layer and go deeper and understand that I'm not just dealing with an assault, it's economic abuse here in this home. It's violence that has been happening for the longest of time in this home, and you start to strip it and find the answers and apply the law, so that then there are consequences to those who are found guilty. So for me is when these laws that we have, and it's a burden already on the police and the magistrate for them to have another understanding on these amendments. They've been struggling to implement the Domestic Violence Act and other acts and not applying them as they're expected to do so. So we've added another layer to them, and we need to be vigilant in them appreciating and understanding why these amendments are important, and what is our expectations as a society, as a nation, on them, right? And that we require a particular posture and a particular professionalism from them to attend to these cases. And I've made an example quickly before Onika comes in. I mean, I went to assist a colleague with a matter at the police station. We went to the Brooklyn police station on Wednesday. And I said to the police officer who was attending to our case, I said, I find it very, and it's quite telling, how the police, when they're confronted with matters of GBV, they literally, it's like they freeze and they cannot extricate from themselves from what they're being confronted with. And in them being frozen, they forget that they are law enforcement officers. Then they want to step in as social workers or something else instead of first remembering that they're law enforcement officers. So, Chair, we will attempt to give some answers in writing, and we'll do so. But I thought I could touch on some of this, and maybe go back quickly to the issue of bail, right? And we are clear in our submission that we recognize that bail is a constitutional right, and so, but almost all gender-based violence cases, it would seem that it was a given that bail will be granted. So and the prosecutors did not even mount a fight at all to attempt to oppose the bail. And what we are requesting this time is that every single domestic violence, sexual offense, sexual assault, sexual violation case, prosecutor must oppose that bail and give reasons. And we need to fight for that bail not to be granted. Because if you look at how long it takes for a matter in this country from when it is reported until it's concluded, I mean, there are cases that take more than a year or 2 years in this case. And you as a victim and a survivor of that violence, you have to live with this delay. So what we need to be expending our energies on and putting resources on is speedy resolutions of these matters. That once I report a rape case, that you have a facility that can do a lab that can do the tracing, the DNA, everything, the clothes are there, you do it. Surely we should be advocating for a speedy resolutions of this case within 6 months. We cannot afford to have 1 year, and that's why women are saying, why I can't be comfortable to see my assailant in the street out on bail, and I'm waiting for justice to take its course. So in all of this, if we don't want to be, we think we are impinging on the right of individuals to have bail, then we should be putting emphasis on speedy resolutions of these cases and not take forever to resolve them. Speedy responses on letters that get written to the Magistrate Commission to deal with these matters. Because when you delay, we are causing more trauma to the victims. There's an issue that we wrote to you as the committee on the SIU and the sexual harassment. I'm still to get a response to that. So for me, it's about just being diligent with the work that we do and giving answers immediately and promptly and swiftly, so that victims don't think that they are being re-victimized and secondary victimization. I'll give Onika quickly to deal with the consequence.
So just quickly on the consequence management, what we are looking for really here is an end to the impunity that is enjoyed by both perpetrators and those who fail to act according to the law. So a good example here is the provision on safety protection orders. We need to be able to say, once it is issued, it can be served within a specific time frame, and failure to do so will result in some consequence against those who are seized with that responsibility. What we have right now is a situation where perpetrators enjoy such great impunity. It doesn't inspire agency also amongst those who are, seized with the responsibility of ensuring that the law is enforced. For us being able to begin to see a speedy resolve of these issues and consequences, one of the things we requested in the emergency response plan of the 1.6 billion was for IPID to actually resolve all the pending cases against police on GBV related cases that they had. And, still 6 months later, we are not getting complete conclusion of those, because there's sort of this level of comfort and knowing that nothing really is going to happen. The same police officer is going to might even get a promotion, for heaven's sake. But the level of impunity exists both amongst the perpetrators and amongst the authorities who assist with protecting us. And I think I just want to conclude by saying that, yes, we recognize the innocent until proven guilty, the right to apply for bail. But we hope that also this committee recognizes the constitutional right to safety. The reason why the 24 demands were delivered by total shutdown, and there were 24, it was to represent 1 year in our democracy that the state has failed to grant women their constitutional right to safety. In 2018, we were 24 years into our democracy, and we, as women, we felt that we still are yet to enjoy this constitutional rights. And therefore, if anything, we would want to see the state and those employed by the state acting on our behalf to ensure that we also are granted that constitutional right to safety as women. We will submit everything else in writing just in the interest of time, unless there's something burning that needs to be addressed. Thank you.
But thank you very much for the opportunity. We really appreciate it.
No, thank you very much for you to respond to the call to make representations to the committee and to enrich the quality of the bill the bills that are before us. But I must indicate one issue, that the issue raised about the SIU, we did take an action. We did forward it to the executive authority concerned, and we were informed that some of the issues are still before CCMA and other bodies. And then once those matters are concluded, the executive authority will act appropriately. So
Thank you for that, Chair. Thank you.
So it's not that the committee did not do anything. The committee unanimously, as early as last year, intervened and referred the matter accordingly.
Thank you. Appreciate it.
Thank you very much.
Thank you.
Thank you. Now I will invite Teddy Bear Foundation. I'm informed that there are still issues with the Western Cape government. We are hoping that during the course of the day they will join. There seems to be some communication problem, but let's hope when immediately.
Let's go.
Immediately when they come, we will slot
this dog unit.
Honorable members, I do understand that Honorable Glenis Breitenbach's dog is not happy with the discussions we are having. Let her take care of it. So we have the Western Cape government that might join us late. They are still, the Secretariat is still in contact with them. There seems to be some communication breakdown. But for now, Teddy Bear Foundation is ready to make a presentation. Teddy Bear Foundation, over to you. Teddy Bear Foundation. Committee Secretariat, have they logged in?
Yes, Chairperson.
Can you hear me, Honorable Chair?
Yes, we can hear you. We can hear you.
Thank you very much. Okay, can you see the screen? Are we on?
I can see a little picture of you.
And the screen, the actual presentation?
Not yet.
We're just testing, sorry. But I'll start in the meanwhile. I would like to take this opportunity to thank Honorable Chair and Honorable members for allowing us this opportunity to make a presentation on the submission of the bills. I would also like to just speak briefly to the background of the Teddy Bear Foundation, who we are and the work we do, and our work within the children's sector. So the Teddy Bear Foundation for Abused Children was established 34 years ago in response to an urgent need for medical examinations for sexually abused children and other forms of abuse. It has grown into a fully fledged service for abused children, which includes your forensic medical examinations, where J88s are completed, forensic assessments, and supportive counseling, ongoing trauma debriefing, psychological testing, and we are also working with children who have to testify in court. And we find that we have been working with your young sex offenders. These are child sex offenders who have committed sexually aggressive crimes towards other children. And we started working with child sex offenders since 2001. We were approached by the Soweto court, the Protea court, where they were seeing many young children, younger and younger, and children even as young as 5 and 6 years old, who were engaging in attempted and full-blown penetration. So we developed a program called the SPARK program, which is a support program for abuse reactive children, and have subsequently refined our program and have published a handbook and manual working specifically with child sex offenders. We are currently finalizing our second edition, and we continue to do a lot of research in this area with your young child or child sex offenders. We've also published numerous articles in this field. We also conduct global action surveys at schools annually with learners, and do a lot of crime prevention and outreach programs to ensure that we are actually in touch with the problems on the ground, that is at grassroots level, and make recommendations and mobilize actions to ensure that the best interests of children are followed. Teddy Bear Foundation is also an official rapid response team for schools in Gauteng when crises are experienced. I'll just give you an example, like the Parktown Boys School, the Enoch Impianzi tragedy where the young boy was drowned, and how we went in as a rapid response team to support and reach out to children who were traumatized, and also reach out to their families. We also sit on various national task teams which are related to children, and our expertise is recognized both nationally and internationally. We've presented on various platforms, international conferences, and local platforms. Our innovations in the field of child abuse management and the development of material has received many accolades on both levels, nationally and internationally. Recently, very recent in the past month, we did a virtual training of early childhood development practitioners on the recognition, management, reporting, and legislation of child abuse, which was commended by the MEC of Education, the Gauteng Education Department, who said it was groundbreaking work and needed to be escalated to the DBE and on a national level. So this, in a nutshell, is basically the kind of work that we do. We work from an ecological framework, micro, meso, exo, and macro level, where we have also impacted on legislation and policy. I think what I would like to focus on next is just social justice, looking at the fact that we always looking at what is in the best interest of children, and of course validating and ensuring that their constitutional rights are always, well, not always, but we try and ensure that children's constitutional rights are not violated. I just want to reflect on some of the work that we've done in the arena of social justice. Some of you will remember, and I think I recall working closely or doing a presentation similar to this, and Advocate and Honorable Swartz was one of the team members or and part of that committee. Teddy Bear Clinic versus Minister of Justice and Constitutional Development regarding the Jules High case. Teddy Bear Foundation went under the support of the Center for Child Law, Professor Anne Skelton, to the Constitutional Court to apply for the decriminalization of sections 15 and 16 of the Sexual Offences Act due to challenges that were faced by children. And this actually was more harmful than helpful because it was violating children's rights and not promoting their best interests. And we found that a lot of the children were subjected to secondary victimization. And the outcome of this was that the Constitutional Court decriminalized consensual sexual activity between children, and of course, appropriate interventions and responses and responsibilities needed to be shared, that it should not be the sole responsibility of law enforcement or the judiciary, but that parents and society has a role to play and fulfill. The other thing that we also focused on was we were amicus curiae for the Center for Applied Legal Studies, where Teddy Bear Foundation with CALS was actually successful in the application. If we just take our mind to the fact that the statute of limitations was only applicable, there was no statute of limitations for rape. However, for any other sexual abuse or violation, there was a prescription of 20 years. And if we cast our mind to the Sidney Frankel case, the philanthropist, and the case where years later the victims made a disclosure and wanted to pursue and wanted closure and wanted to see justice being fulfilled, they were not in a position because of the prescription of the limitations. And in this application, there was amended relief provided for children and adults. And of course, the prescription no longer applies. Hence, it was a successful outcome. TBF also has been working with many other platforms, national platforms in the children's sector, working with and supporting the Children's Institute on the issue of the abolishment of corporal punishment at home, working on positive parenting and working on different levels. So once again, not just working with victims or victimizers, but at a broader level, working even within the corporate sector where employee wellness programs address many challenges around parenting. We also look at the best interests of the child and look at ways of helping children and not harming them. Our objective is to protect and prevent violence against children. So now, coming to the current proposed legislative changes, I just want to say from the outset, I think it's important that we stipulate that TBF endorsed some submissions by Professor Anne Skelton. We endorsed the submissions by the Center for Child Law and the Shukumisa Coalition, of which we are part of. And the TBF was also a representative on the Interim Steering Committee for Gender-Based Violence as part of the Shukumisa Committee and representative. So with regard to our comments regarding the submissions, I think we need to realize that the new laws would have to be policed, it would have to be managed to ensure proper implementation thereof. in order for the changes to be effective. There's always the monitoring and evaluation component, which is critical and essential, and it's something that we cannot, ignore. So now I'm going to look at the domestic violence. Now, I think I need to express my humility around the subject. I am not an expert. TBF is not an expert on domestic violence. Whilst our mandate and focus is on children, we have found ourselves in a situation that we cannot separate ourselves from domestic violence. There's often a co-occurrence of domestic violence and child abuse. And we have found in our clinical settings that more than 50% of children who come from a situation of domestic violence are at risk of being abused, at risk of being violated. And I think this is something that we need to focus on, and that is why we have come into the equation of domestic violence and have found ourselves in a situation where we cannot separate ourselves, or we cannot turn a blind eye to this. So it is often, I think, what we've realized, that violence against women and violence against children reinforce each other. They perpetuate the cycle of intergenerational violence, which has been highlighted through numerous presentations through this process. And I want to also elaborate that the NSP speaks to both violence against women and violence against children. But we need to ensure that children's issues are not diluted, because often children are seen, children are hurt, H-U-R-T, and are not heard. And I think that is something that we need to take cognizance of. So with regard to the domestic violence, I think we need to understand that it is often difficult for victims to report domestic violence, as they are, and we've seen this through COVID-19 and prior to COVID-19, that the economics do not allow them, they do not have the means to escape from this situation, from this violation. Whilst the proposed act increases protection for victims, it must be enforced with commitment by all stakeholders concerned. And I think it speaks to the first responders like law enforcement. And I think my learned colleagues whom I sit with on Pillar 4 in the task team of the NSP spoke to police, they spoke to the prosecutors, and the enthusiasm and the knowledge, the skill, the training, that all of that is critical. And therefore, the commitment speaks more broadly to those specific responsibilities, attitude, and ongoing training, and ensuring that they receive the specialized skills. We also need to look at the fact that there must be a system in place to ensure that all cases are treated professionally from the point of reporting, regardless of the views of the sex representative. So ultimately, training is key as our specialized officers. We cannot just take somebody with general training, your generic officer, to actually reach out, because as my eloquent and dynamic speaker, Advocate Madhumise, said, that they actually need that specific training. They freeze at the moment when they're presented with these GBV cases. So resourcing courts, training officials, whether it's SAPS, health, your departments of social development, and even education officials, I think that is key. We've already spoken to the need for first responders, but I think we also need to be aware of the fact that they also need support. And I think that is something that has been recognized in the global literature, that officers who are on the front line also suffer victimization, trauma, and vicarious trauma. So I think we need to make provision and address this. It cannot be glossed over. The fact that cases resources are being turned away, and we've seen this repeatedly, can have long-reaching effects on victims, sometimes with long-term health implications, your STIs, your STDs, HIV, pregnancy, etc. And I think we need to leave the decision regarding false allegations to the courts. Another reality is that crime statistics are inaccurate as a result of cases being dismissed or not always being followed through in the manner in which it should be. The lack of follow-up on complaints received, I think your LGBTQIA, and I think somebody mentioned earlier, Onika spoke about correction, of sex, something that we in the children's sector are seeing, that this is even a fact experienced at school, where children are afraid to report, they're afraid that they will be victimized, and they are being victimized. The bullying and the correction of rape, where they are being sexually violated because of their orientation. We also need to look at the fact that perpetrators are not always being arrested and are not being held accountable or being brought to book, so there are not, actions do not always have consequences. So what recommendations would we like to make is the inclusion of same-sex couples, the Shukumisa recommendation of the recognition of ukutwala as a crime, we support that, and recommend that virginity testing be criminalized, that it's not acceptable. Looking at the sex offender register, I think this is something, an area which we feel very strong about. Currently, as we are aware that South Africa has 2 registers, the NSRO, which falls under the Ministry of Justice and Justice and Correctional Service, and the National Child Protection Register, which falls under the Ministry of Social Development. Now, if we look at both of these registers, the NSRO makes provision for sexual offenses and does not make provision for murder or physical abuse or any other form of abuse. And your NCPR, National Child Protection Register, Part B of the register speaks to people who are found unsuitable to work with children. But even if we just look at the population of this register, just going back in time, even going back earlier this year and a few years, the number of cases that have been actually documented on this register is questionable. I think we need to understand that. And I just want to share something with you. I've been working with a case, an educator who slipped the system on numerous occasions, and each...
Ms. Omar?
Yes?
Ms. Omar?
Yes?
I want to remind you that you have 3 minutes.
Okay,
you have
thank
3 minutes left.
Okay, thank you. So this educator slipped the system each time, and he was employed by the SGB, but the long and short of the story is that each time there was an opportunity for an allegation to be made against him, he fortunately slipped the system, and there was no report on both registers. So if this was captured on a criminal record system, he would have been, any of his future employers would have been alerted to this injustice. I think the important thing is that we need to understand that a different approach to children for intervention, rehabilitation, and reintegration, and that we cannot use the same approach for children and adults, and that the 2 registers require huge budget allocation of resources, and it is a duplication. The important thing to understand is that to have a comprehensive criminal record system, which is managed by SAPS, and that children cannot be treated in the same way as adults. Making the register is not the solution to the public, is actually not a solution to the problem. We cannot have mob justice. Vigilantism is going to create further problems and result in further violations of innocent children, families, and I think that is something that we need to understand and appreciate, that All public comment and previous well-known issues and complaints need to be addressed by the responsible bodies in order to ensure an effective and fair outcome for victims. We need to strengthen one criminal record system, which is managed by SAPS, and to ensure that we avoid secondary victimization of children. Thank you.
Thank you very much, Ms. Omar. I lost you a bit. My connection is unstable. I will now open to members to ask questions. I have Honorable Swart as number one, Honorable Jakim Fukeng. Those are the two hands, and I think Honorable Nevold Drachens. Those are the three hands.
Thank you, Chair, and thank you to Ms. Omar and the Teddy Bear Clinic for your presentation. It's good to see you again after many years. I just again want to commend you for the work that you're doing, as many of the other civil society organizations are doing. And I think one of the important lessons we learned as Parliament following your successful matter with the sections 15 and 16, that decriminalization matter, was the unintended consequences of passing legislation which we thought had a good intention, but at the end of the day had a negative impact, and it was quite a lesson we learned. And I think, Chair, this is a lesson we need to learn as well when we are dealing with these pieces of legislation, is unintended consequences. And I think in that particular case that you were very successful with, it was very important there that we realized that we were trying to deal with the problem of children, promiscuous children, from a criminal justice perspective, as opposed to a societal issue. And I think you made that point very well in the court and in subsequent engagements with the committee, and you made that point again today. Now, the relevance of that for our dealing here is, I think, although the GBV violence is at the forefront across the nation and at the forefront of fighting, it must be the criminal justice system, but there's also a societal need. And maybe you could unpack that a little bit more as to what role can we, as public representatives, as society in general, engage with fighting this, raising awareness, being aware of what's going on with our neighbors, also being a societal issue. The next issue I
person. And thank you to the Teddy Bear Foundation for their presentation today. And thank you as well for the work that you do, especially with children. I haven't picked up anything about the Thuthuzela care centers in your submission. I'd like to know if you have any kind of relationship with Thuthuzela care centers, and in your view, you know, should it be, I mean, we have 55 as far as we know. So what is your view on Thuthuzela care centers? Should they be increased? And secondly, mandatory reporting. So I've heard during these days, during these public hearings, arguments against and for mandatory reporting, unless it's for children. And, you know, I understand the arguments presented, but at the back of my mind, I really wanted to ask your view about, you know, I'm wondering that if there is a silent cry for help. Yes, many people say don't disempower the victims, don't take away the decision-making right of an adult. They have the right to report. But sometimes I wonder that is there this silent cry, you know, or this hope that somebody will make the report for them? Or, for example, the children who are witnesses to abuse and they know that their parent, their mother doesn't want to report the abuse. But maybe the child then has a silent cry, has this deep hope that somebody, the neighbor, will see and report this. You know, do we take this into consideration, the silent cry for help, where there's nobody to help, and then, you know, the matter becomes too late, in a manner of speaking? Thank you very much, Chair.
Well, thank you very much, Honorable Nebot Dahans. Over to you, Ms. Omar and the team.
Thank you, and thank you for all the questions. I think they're all incredibly important. So coming to Honorable Swartz's question, what role can we play? I think that is a brilliant question, because everyone has a role to play. It's not just NGOs, not only civil society or government, but everyone has a huge role to play. So we need to look at prevention and intervention in tandem. The two need to be coordinated and integrated in the response. So already at a young age, where children are 2 and 3 and 4 years old, where they're developing language, vocabulary, we already need to engage with children at that ECD level, making them aware of their rights, their responsibilities, safe, unsafe touches, but taking it to the next level, to your primary school, senior primary, high school, your tertiary institutions. Your corporates need to come on board within the workplace settings where opportunities are created, where people are given the platform to understand and appreciate their rights, their responsibilities, but also opportunities to develop insights into empathy, insights into understanding what it feels like to be a victim. So the deep sense of getting into the shoes of another person. So I think it's not just the role of your antenatal clinics or your schools or your educators, but community platforms, using your commuting platforms where people get onto taxis or public transport facilities, also handing out information within those settings. So again, as you know, I would say that the protection of children, protection of people is not my business, it's not your business, it's everybody's business. If we want to make a difference, we all need to work together, because no action is an island, it's part of an organized interaction. The implementation of training of police and NPA and all other officials, I think Honorable Swartz raised a very important thing around the lack of sensitivity, and something that when people start undergoing opportunities to express feelings, to actually go through this empathy training, they realize through role plays actually, realize that being in the shoes of a victim, being in the shoes of somebody that is vulnerable and powerless and defenseless, and when they have to ask for help, they don't know how to ask for help. So, you know, doing that role reversal and going through that simulation could also instill some sense of deeper understandings and make them appreciate and understand what it feels like. But at the same time, we must not gloss over the trauma that all these responsible bearers of duties are facing, because the vicarious trauma, you know, the transference and counter-transference, where they see themselves or their children or their family members in similar situations, and the emotions that it may trigger, I think that is something we cannot oversee. And it needs to be ongoing, consistent support in a platform which is confidential and private, where they would not be exposed to, say, they've sought out professional help and are seen as somebody more vulnerable or weaker. I think often law enforcement officers feel compromised because of that. The virginity testing, I completely agree with Honorable Mofokeng that we have to consider, traditional practices, but at the same time, we need to look at the Children's Act, which supersedes everything else, looking at the best interest of the child. And we know that the virginity testing is not 100% foolproof because there are other ways of penetration. And I think what would help here is, again, developing deeper insight and understanding and awareness raising, conscientizing people around the unintended consequences of this virginity testing, where I know I worked with a colleague who was previously the director of Childline National, and they did studies where there was a lot of anal penetration. So whilst the girls were being tested vaginally and cleared for the virginity testing, there were unintended consequences as a result of that, STDs, STIs. So I think these are things that the more we create awareness, the more we create community dialogues and platforms for dialoguing, people will have deeper understanding and focus on what is in the best interest of children, in the best interest of family and community. Honorable Newvote spoke about Tutuzela care centers. Yes, we do have engagement with Tutuzela care centers, and I think our concerns within the Tutuzela care centers is that, yes, we support the fact that it's, everything under one roof, but again, in terms of allocation of resources, the resources are not always available due to budgetary constraints. So that is something that one needs to look at. But in terms of mandatory reporting, once again, we all need to, the more awareness raising, the more people are held accountable for not reporting, we will find that more people will come forward and report. In terms of the Children's Act, the Sexual Offences Act, that would certainly assist further violation of victims. Then I think something that really sort of resonated with me is the silent cry. I absolutely agree. Because during COVID-19, that is what we saw, where victims were trapped, immobilized. Home is supposed to be the place of safety, and home is the place of hope, but it became the place of danger, where children could not actually reach out to their peers, to their educators, to the life orientation or their coaches, sports coaches. They couldn't reach out to anybody and were subjected to brutal violation. Some of them were inflicted with severe physical injuries and, of course, without, and also emotional abuse as a result of that. But the fact that they were powerless, helpless, and there was actually nobody out there that they could reach out to. So we need to actually create spaces or situations, and I think that is something that we've been discussing with the National DSD platform on referral pathways, on go-to persons, your street elders, your safety network within the confines of your neighborhood, and to actually ensure that maybe children be given a whistle, like a real whistleblower or some kind of device, because we know that cell phones were actually taken away from children during this period where they had no access to any kind of resource or support. So we really need to focus on these silent cries and try and enable children that cannot come out of that situation to have access to some kind of support or recourse. Thank you.
Thank you very much. Thank you very much, Ms. Omar, and to the Teddy Bear Foundation, and thank you for the submission. Honorable members, we will now invite Voice It in Action. Have they logged in?
Hello, yes, we are in.
Thank you very much, sir, and welcome. We will give you 20 minutes to make a presentation. You can start.
Sorry, I'm just having a bit of trouble sharing my screen at the moment. Just trying to sort that out.
We will give you 2 minutes to work that out with the assistance of the committee secretariat. We will start at 12:15. That will serve as a comfort break for members.
It's Sia. Good day, sir. Mr. Moloto.
Hi, Sia.
Sure. Do you have the icon next to the chat box that says share screen?
Next to the chat box, I see share screen, yes?
Yes, that one. Can you click on it?
Yes, I've clicked on it.
It's not
and it gives me, it
says,
give you,
say?
It's not giving me the options. It's only giving me who can share, only hosts or participants, but not more than that.
Okay, let me quickly.
Okay, no, it has. Okay, it has.
Can you share it now?
Okay.
There we go.
There we go.
Okay.
All right.
Okay. Over to you at 15:15.
Awesome. Thank you very much.
Sure.
All right. Good morning. Actually, good afternoon. My name is Kotatso Moloto, and I am the founder and president of Voice Sit in Action. Just a bit of background on what Voice Sit in Action is before we actually get into the crux of today's discussion. Voice Sit in Action is a non-profit company that is aimed at creating innovative solutions to curb the heightened violent culture witnessed in our communities through innovative campaigns, through innovative solutions in the form of campaigns, programs, and services. Our vision is to educate and empower individuals for the future. We believe in education and its key role in changing the problems faced by South Africa and in empowering
Mr. Moloto is still there?
Yes, I'm still here, sorry. And in empowering South Africans in better participating in socio-economic issues. Voice Sit in Action was formed in 2015 after a traumatic incident of a kidnapping and eventual murder of Ipileng Christine Moholane, who was only 19. So Voice Sit in Action is actually 5 years old. Our global aim, our motto, and our vision is summarized through our mission, which is to stand and fight against violence and its effects in the community in order to protect those who need it the most. We have a saying that a safer, cleaner, and sustainable community is possible through combined efforts. We do not have all the resources as of yet, but as a developing organization, we understand that it's going to take some time. We work in terms of, creating awareness around cases that are pending and that have been open, but not finalized in the justice systems, that would have issues when it comes to the police stations, as an example. We ensure we support families, we create awareness in those activities or in those communities and in those families to ensure that their cases are heard and justice is served. We've been working on various cases, justice for Tinyiko, justice for Polina. We'll be working on many others as well. We currently rely on a strong volunteer base, and we'll be going forward, we'll be reaching out to more representatives who can come and participate and work in the organization to ensure that justice for all victims of GBV can be achieved in South Africa as an immediate requirement. Otherwise, the problem is if this first point is not achieved, the desired changes in our communities will never be achieved, because people will not see any value in the justice system or in the policing system, because we've got cases that have been opened and are still open and not finalized, and that have been there for over 5 years, over 10 years, and there are still, no tangible results. So we will be ensuring that these cases get closed and finalized with verdicts and sentencings. But that's not the only thing that Voice in Action does. In dealing with violence in our communities, we'll be looking at various other programs, the eradication of homelessness, ensuring that we can get to train communities. We've actually done a beta test of a training program that we have developed as an organization, and we will bring more of these going forward. And some of the programs are available on our website for additional details. Now, coming back to our presentation. As Voice in Action, we welcome the draft bills on gender-based violence, the criminal law, the Amendment Act Amendment Bill, Domestic Violence Amendment Bill, and the Criminal and Related Matters Bill. These bills are a fundamental step taken by the President towards fighting the GBV pandemic. Voice in Action offers its full support in seeing the content of these bills come into fruition. However, these bills are missing responses to GBV that South Africa requires immediately. On the 5th of September 2019, President Cyril Ramaphosa stood in front of us as a nation and declared violence against women and children a national pandemic. A year later, we still have an alarming and rising number of cases. In contrast, on the 15th of March 2020, President Cyril Ramaphosa presented us with an invisible enemy, COVID-19 coronavirus, as a national pandemic. 2 days later, borders were closed and the economically literally shut down. In less than 6 months, the scourge of cases was curbed, and the enemy that threatened all of us, including millions of men, is being managed. COVID-19 is being managed all over South Africa and the rest of the world as the race for long-term sustainable solutions are being developed. Likewise, as Voice in Action, we request the Portfolio Committee to consider setting up a gender-based violence command center that will treat GBV and femicide as the national state of disaster that it is. Voice in Action proposes the following immediate solutions. Applying the same urgency and drastic measures taken to protect South Africa against the impact of COVID-19 into protecting the country's vulnerable groups against GBV and femicide. Creating integrated and coordinated disaster management mechanisms that will focus on preventing and reducing GBV, e.g. by setting up more enhanced emergency, rapid and efficient emergency response systems that are effective and will mitigate the severity of the impact of GBV as a pandemic. Providing of reports of GBV from all police stations, including tallies on cases reported and the number of cases solved. This must be followed by extensive analysis and studies that will aid in uprooting the casual effects and of the exacerbated gender-based violence in South Africa. This will also determine an accountability mechanism for both the perpetrators of GBV and the justice system that is currently showing no consistency for justice to victims. For example, if we have a high-profile case, this case will run and it will be, in and out of court before you know it, it's done. But cases that are not within the public space or not within the public eye will never get the same attention, thus resulting in this prolonged cases that are spanning over 10 years, over 5 years, over a year. Following the extensive analysis on the progression of COVID-19 coronavirus worldwide and in South Africa, tallies and extended studies were made. We must also have the same energy and action implemented for combating GBV, including daily, national, provincial, municipal, regional, and police station tallies on cases reported and the number of cases solved. This will help in a great deal because when we have this information, we know where to move forward from. We know how to hold our government accountable and the different law enforcement agencies. The same energy we had different departments share knowledge and shift funds in order to combat COVID-19 coronavirus. We must have different departments sharing knowledge and shifting funds for the thousands of victims, the millions who are still at risk, and those who are and who will be left destitute due to GBV. And this one really pains me because we tend to forget about the secondary victims, those who are left behind after an incident of this nature. For example, one of our cases in Mpumalanga, where this lady was murdered in her own home by the boyfriend, and she has left a child. The child is left in the care of 2 boys, men, and we don't know what would be the outcome of that. So something needs to be done to ensure that those who will be left destitute are protected in the long run by government and by the laws that we are developing. While we wait for the enactment of these very critical bills, immediate action is required to protect South Africa. This is the basis of our comments on the bills. A plan to ensure justice for all victims of GBV in South Africa. Unfortunately, because of the Disaster Management Act, which does not legally allow any entities, including groups, individuals, organizations, etc., and to advocate and demonstrate justice for victims of GBV. Understanding and knowing that the current possibilities do not cater for all. For, like example, social media or virtual engagements, these are not enough. Therefore, not reaching all South Africans, which forces entities to postpone awareness, educational, and preventative initiatives for after this act has been lifted. And we've seen this during lockdown as well. The cases were climbing, and as the previous presenter had mentioned, during COVID-19, victims of GBV had nowhere to run. They were within the space, and organizations who were trying to assist or trying to help or doing something to mitigate the problems could not do any of this because of the laws that were enacted. The reality is that GBV doesn't have a date, nor are the acts currently working in favor of the countless victims we are seeing every day, everywhere. As a leader, I believe we should not wait until we have, until that time, or postpone any activities, initiatives around GBV, because we cannot guarantee whose child, mother, sister, friend, or colleague will survive the next day. While we wait and hope for the president, the government, and parliament to organize the affairs around the GBV pandemic. Is GBV not declared a pandemic? Then if that is the case, then the Disaster Management Act should also accommodate GBV, thus ensuring the immediate protection of the most vulnerable groups and ensuring that the bills that are in discussion now are implemented rather than discussed. Because in the implementation of these bills, while sorting the cases, a lot more can be achieved. Because currently we are just discussing the bills, but there are people out there who are still waiting for government to do something. And that is not, we need to do more. We need to do more than just discussing. These bills in discussion whilst dealing with cases could have been a perfect strategy to deal and to ensure that the community sees that government is doing something and that they find hope and they can trust again the system that needs to protect them. But for now, it seems as though not enough is being done to protect the people. There are countless causes of GBV. And as an organization, we have identified the following causes. These are multiple causes. They include, but are not limited to this: gender inequality, poverty, poor education, inconsistency within the justice system. As an organization, we have also identified the following possible solutions to GBV/F. As we know, GBV is not an elementary problem. Therefore, the solutions themselves are much more complex. They include, but are not limited to, equal opportunity, economic inclusion, quality education, advocacy, and accountability systems. A pandemic within the pandemic requires extraordinary steps by individuals, organizations, and government to rally until justice for all victims of GBV is achieved, and still protecting the millions of potential victims. As an organization, we have developed a program which is called Justice for All, which is an initiative to educate South Africans on the severity and reality of GBV as a pandemic. This is a required collaborative strategy that needs to involve all of South Africa, ensuring that justice for all victims of GBV and the educating of the future which will protect South Africa against GBV in the future. As our previous speakers have mentioned, we cannot have solutions that are one-sided. Our solutions need to have this double-edged sword effect, where we are dealing with the legislation that is missing whilst enacting some of these laws to ensure that, we are moving forward strategically to achieve the objectives. Our objectives are there to educate our community on the severity and reality of gender-based violence as a pandemic in all 11 official languages. Most of our communication has been coming in English. And we know in South Africa, we have got 11 official languages. What about those who don't really listen and actually interact when we're starting to speak English? So our solution and one of our objectives is to ensure that we educate the community in all 11 official languages to ensure the protection against GBV with key focus on the most vulnerable. How do we protect the most vulnerable? We can protect them as a starting point by ensuring that all cases of GBV are closed. Then the victims and the secondary victims will be able to live and continue living and to also enjoy some of the economic opportunities that can be created. But if that is not achieved and that is not done, some of the laws that we are putting down will be useless because the victims themselves are left out when dealing with the problem of GBV, because they are put last, because the perpetrators, it seems as though the perpetrators have got more rights than the victims. We also will be encouraging youth participation in this community changing project. It is clear that our youth are not participating enough in these programs. And that's why it is so high that youth are the ones who are perpetrating these crimes. Creating additional employment opportunities. The reality is that if we do not create employment opportunities to empower communities, some of these problems will be perpetuated, because we know that violence exists and continues because of a lack of opportunities in most communities. To enable additional economic activities for South African entrepreneurs, there is no way that we can talk about dealing with GBV without ensuring that the economics around it is covered. We need to ensure that we can also empower businesses so that businesses can also have a hand in dealing with the problem in their communities. And I'm talking about local businesses in townships, in rural areas, and the likes. To foster a spirit of working together between society, law enforcement, and other organizations to ensure change, justice, and to ensure the eradication of GBV.
Mr. Mloto, you have 4 minutes.
Thank you. This one is very crucial. We need to start working more together. It seems like there's a handful of people who are running these activities, but it's not enough. We need to start pulling together as society, and I believe that if government really deals or treats GBV as a pandemic, we would then start to see the changes that are required. We would then start to see the movement of people. We would then start to see the changes that are required. And lastly, one of our objectives is to create and test new ways of working to address societal ills during and beyond the current global pandemic of coronavirus COVID-19. The reason why we had to take this direction is because COVID-19 showed us that it is possible. How is it possible? Government needs to make the right decisions. Otherwise, our bills and our laws that we are creating will just be talks. They will not deal with the challenges that are happening. We have to deal with the problem whilst running with the changes that are required. If at all there's a case, and these bills were applied to the cases, I mean, this would be helping. This would ensure that we have tangible results whilst we are looking into these bills, and these bills would serve, as education for that family and the community would be surrounding this particular case. But it will not be isolated. Currently, this discussion is very isolated. Those who do not have access to interacting with this platform or virtual platforms are excluded from this. And that's one of our challenges that we had seen. And that's why we had to take this angle when we were discussing and coming up with a response to the three bills. And as a closing remark, a pandemic within a pandemic requires extraordinary steps by individuals, organizations, and government to rally on until justice for all victims of GBV is achieved, and still protecting the millions of potential victims. I thank you. A safer, cleaner, sustainable community is possible through combined efforts. And if we only work on one aspect, we will not win. We will have these problems as they are continuously happening, still happening outside whilst we are discussing potentials to change. Thank you very much for this opportunity. I hope that going forward, we'll be able to do a lot more in dealing with the problem of GBV rather than just having conversations around bills that would be implemented in the future. Can we have solutions that talk to this problem immediately?
Thank you very much. I will now note honorable members for questions and comments. I have Honorable Jakim Fukeng. I have Honorable Xolanqola. I have Honorable Werner Horn. In that order.
Thank you very much, Chairperson, and thanks to Voice It in Action. Maybe, Chair, I should try maybe a little bit of making Mr. Moloto to understand that there are other platforms that are given by Parliament for people to reach the discussions. If maybe you were not aware, there are a number of them, but it's okay. I just want to check on the issue of you are suggesting or recommending that they should set up a gender-based command center. Now, what about the proposed GBV and F Council? The second part will be saying that you said GBV, yes, it's a pandemic, therefore a disaster management should be considered. How do we do that? What is the role of the police, justice, department, social development, and all that? Maybe that clarity. Thank you very much for your presentation. Thanks.
Thank you very much, Honorable Mfukeng. Honorable Xolanqola.
Thank you very much, Chair. Let us welcome the presentation by Voice It in Action. Chair, just two issues. Voice It in Action convicts that amongst the causes that cause GBV are issues like inequalities, poverty, and other things that they have listed in their presentation. The first question that I would like to check with regard to that, Chair, is does the Voice It in Action have a firm view that GBV does not occur in affluent families or affluent communities? Maybe if they can take us in line with their view on what actually causes the GBV. The second issue, Chair, is on their justice for all program objectives. They ensure progress to the vulnerable groups. I would like to check that how maybe they must make us understand how do they go about ensuring that protection. Maybe a closer example would be on that have they been, was when I checked their establishment, they were established on the basis of a certain case of GBV. So it has inspired the thought of ensuring that they establish this NGO. So have they been throughout since 2015 been part of any court proceedings of GBV? For example, being an amicus curiae in a court proceedings or involving a GBV case. Thank you very much.
Thank you very much, Honorable Mola. Honorable Vernahon.
Yeah, thank you, Chair. And I think we take note of the passion around this presentation, and I think what the message we must take away is that indeed there's a justified general outcry in South Africa that urgent attention to this so-called second pandemic is what is needed now. But in line also with questions asked by other colleagues, I would just want to make the comment that I think the one very helpful suggestion would be that we, apart from the SAPs getting sexual violence related statistics when the crime statistics are released, we should possibly consider working hand in hand with our colleagues in the Portfolio Committee for Police and even the committee looking at having oversight in the presidency over affairs of women, children, and people with other vulnerabilities and disabilities. Working with them in order to also get some structured form of statistics regarding the GBV type of complaints received at the different stations, how many of them ultimately result in protection orders and how many of them result in criminal action being taken. I think that type of exercise, Chair, while this is strictly speaking not related to the bills, will also assist this committee to fulfill its role of oversight better. And I think we must be thankful for that suggestion. Thank you, Chair.
Thank you very much, Honorable Hon. Over to you, Mr. Mlongo.
Thank you very much. The first question, I couldn't get them clearly due to our reception, so I'll jump into Nwala's questions. And to answer the first one, no, we're not saying that GBV only occurs in affluent homes. No. GBV happens everywhere, but it's predominantly happening within these environments where poverty is rife. Because when you think about it, they have no way of speaking, they have no way of defending themselves, and they are caught up in the space that they cannot come out from because of a lack of these resources. Now, when you consider the family structure and the person has nobody to turn to, they would then remain in that space, and it becomes an exacerbated issue for that particular area. So it does not just exist in poverty-stricken areas. No, it's everywhere, but it's more dominant in these environments that we have indicated as an organization. We have supported cases, and one of these cases that we have supported for over 5 years, for 4 to 5 years, was the Tinyiko case, which was in Ekurhuleni. So we have supported cases, and there are other cases that we are supporting as well, providing forms of support. We might not have the resources but we then create solutions, because as an organization, we create solutions around the problem. Some of these solutions would involve bringing communities together around the issue to say that as a community, this has happened, but going forward, how are we going to deal with it as this community for this particular issue? We're also looking into ways of working with community policing forums to talk and to address these issues going forward. We were discussing as an organization to say that going forward, all community policing forums that are specifically have high cases of GBV need to be interconnected, because you might find that in certain areas they don't have the right support, but in another area when they are communicating, they will create the necessary support required. So that's just on the cases. We have worked on cases and we are working on other cases as well. Thank you again for our last question and our last hand actually for acknowledging this passion that is fueled in the organization. And I believe that there are more people out there who can do the same work that is being done, just that the right resources are required, the right enablements are required, because when you notice conversations around GBV, they happen only in affluent areas. What about areas where we don't have such affluence? You know, and it also comes back to that view that no, it's not just happening in affluent areas or affluent families, it's happening predominantly in these environments. But however, the affluent areas have got mechanisms to deal with these problems. And in these more challenged areas, there is not enough being done to deal with the challenges, basically. Thank you. I hope I have answered the questions fully. Otherwise, please reiterate and I'll try to answer again. Thank you. Just the first question again.
Okay. With your permission, Chairperson.
Okay, you can proceed.
Okay. Now, I was saying that you were proposing that the gender-based violence, there should be a command center. Now, my question was, what about the proposed council for GBV? And the second one, you acknowledge that GBV is a pandemic, therefore the disaster management should come in place. Now, my question was, what about the issues of, what about the role of police, Justice Department, and social development? And I think I will also be interested on the last part that was asked by Honorable Ngola about being friends of the court. Being supporting in being friends of the court is two things, because then we want to find out that you have support with attorneys going there. Thank you.
Thank you, Honorable Mr.
Okay. Noted. The proposed council, it's still proposed. And when we are saying we need an immediate council, it means that it should have been actually running. The proposed council is a good, but it needs to be running. When we look at the GBV, not the GBV, the COVID-19 council, it was very active from initialization. So we need to have something similar with the proposed council for GBV as well. It's a good strategy, but it needs to be implemented sooner rather than later. The roles of the police, the justice system, and social development within GBV being treated as a pandemic would include education. Because when you look at COVID-19, there was a whole lot of education around GBV, around COVID-19 as a pandemic. So the role from social development would be to ensure that education reaches everyone, to ensure that we have people on the ground in the communities raising awareness, doing conversations, obviously having the right type of protection, but still going into these communities to raise awareness, happening nationwide, not just in one particular area. The duties of the police would be to ensure that perpetrators, especially within the GBV pandemic, in the pandemic, that perpetrators of GBV are not roaming around freely, but are behind bars because of the act or the disaster management law that has been enacted. So the police would be ensuring that anybody who is accused, anybody who has, some type of GBV in activity related matter, that this person is behind bars and it's protecting the family or it's protecting the vulnerable groups. The Department of Justice, on the other hand, would be ensuring that all cases of GBV are being prioritized and closed. That would fast track the work that is being done by the police by apprehending the criminals or the potentially accused. It would fast track that. And plus social development would be doing training on the ground, which means that more people are now starting to speak about their challenges. Therefore, the system being operationalized in the policing precinct and in the Department of Justice working, the community now sees that, okay, I can also come forward with my case. Now, when we talk about being friends with the courts, we have not had time to engage in that area, but going forward, we do note it and we will look into it on how we can achieve it going forward as an organization. But we have partnered with various police stations, ensuring that we can do awareness in the different communities, ensuring that when there is a case, we can actually also somehow get information from that case, from the police station themselves, and work together with the SAPS to educate the community, to ensure that the community understands their role in dealing with GBV cases in particular. So there's still a lot of work that needs to be done. And yes, we do note this input, and we will look into it definitely. Thank you, Chair.
Thank you very much, Mr. Moloto. And also, we do take into account that being friends of the court can also be an expensive exercise for NGOs like yourselves. But we also take into considerations the innovative ways that you are embarking on to support victims. But it's something you're working towards achieving. But thank you very much for the presentation. We would ask you to remove your screen so that we can allow another organization to be able to flag their screen.
Thank you very much.
Thank you very much. Thank you very much, sir. The next organization, let me just check my documents. The next organization is South African Women in Dialogue. Are they in? The South African Women in Dialogue, are they in?
Could they check?
Mr. Mpanjeni?
Yes, Chair. They are not yet in, Chairperson. They had a bit of difficulties in logging in. But then I think I've spoken to the Women's Legal Center. They are here. And Prof. and Skeleton, they are here. We will be sorting them out meanwhile.
So can you take the next one? It is the Women's Legal Center.
Good afternoon, Chair. Are you able to hear me?
We can see you, we can hear you, we can see your presentation.
Excellent. Thank you very much. I'll just start it.
Thank you very much, Advocate. We will give you 20 minutes to make a presentation.
Thank you very much, Chair. Good afternoon to you and your fellow Portfolio Committee members. Thank you very much for the opportunity to present to you this afternoon. My name is Bronwyn Pithy. I am a lawyer with the Women's Legal Center. Just very briefly, my background is that until 5 years ago, I was with the National Prosecuting Authority and was with them for 15 years, working together with colleagues in a specialized unit on gender-based violence issues, and subsequent to then have joined the Women's Legal Center. basically, the Women's Legal Centre very briefly engages in a number of activities. The primary one really is around strategic litigation, around the work that we do based on the cases that we hear and from people that consult with us, together with advocacy and training. Our main area from which we draw our cases is our legal advice unit. And the reason I just want to touch on this briefly is that we really do base our cases, our litigation cases, on the matters that come through our legal advice unit, as well as our legal advice clinics, which are based at the Cape Town Magistrates Court as well as in Khayelitsha. And although we see a very wide range of cases, including housing, evictions, divorce matters, etc., we see a very high number of violence matters involving both sexual and domestic violence. And just in our small office in Cape Town, we see in excess of 250 cases a year, in addition to the matters that we deal with in our Cape Town court, at the Cape Town Court and Khayelitsha office. So these cases really do give us an indication of which cases we need to strategically litigate on. And as some members will be aware, we litigate in our own name, as well as with reference to the previous discussion now around as amicus, a friend of the court. So there are a number of ways in terms of which we intervene. And then also the work that we do directly with women also informs a lot of the input that we then make around legislative amendments. And it really is based on the experiences of those women that our submissions today are based. Before I embark on some details around our submission, I think it's useful, and I am aware that there have been a couple of organizations in the past few days that have made presentations to the committee, just to have yet another look at the picture of what the criminal justice system and how the criminal justice system is managing sexual offences. Although our submissions will cover both domestic violence bill as well as the issues around sexual offences, I think it's important just to have another look at these numbers which are very sobering. And although there is no doubt that there will not be many people in this country who will deny the fact that we have an incredibly challenging problem with violence in this country, and especially gender-based violence, what we do have to question is how many of those cases are seen right through the criminal justice system. So if one has a brief look at the table in front of you, the top line looks at the number of cases that have been reported over the last 5 or 6 years, averaging in the last year just over 50,000, 53,000. But if one looks down and then looks at the number of sexual offences verdicts, which means that those are cases that actually go to trial and there is a finding of either guilty or not guilty, we see a really big drop of just over 5,000 or 5,500 matters that were finalized in the last reporting year of 2019 and 2020. The next line is the sexual offences convictions, which is just over 4,000. So although the National Prosecuting Authority is reporting a conviction rate of 75% in its last reporting year, with all respect to the NPA, this is a little disingenuous, from the point of view that they are working out the conviction rate on the number of matters that they take to trial and not in the number of matters that are reported. And if one looks at what I believe is the true conviction rate, you're looking at a conviction rate of just under 8%. So what is really happening is the question. This is just a snapshot, just graphically can show you, although this was using numbers from 20 years ago, unfortunately the picture hasn't changed, and that's really why I've put it in, is that nothing has really changed over the last 20 years. If you look at that, the number of cases that are reported on the far left, right down to the far right, the number of cases which are guilty. So again, we're looking at a conviction rate there of 7.7%, and as I showed you last in the previous slide, a conviction rate of 7.8%. So my question, what I said just now, is what's really happening? What's really happening is that up to 90%, in fact, more than 90% of reported sexual offences cases are lost. Women are encouraged to report. And although I am talking about women, obviously it applies to children as well. But they're encouraged to report, and we say we encourage people to speak out. But when they do, the reality is that the criminal justice system is rejecting them. And while one cannot in any way undermine the horrific levels of violence that are perpetrated against women in this country, the vast majority of sexual offences matters do not involve overt violence. They do not involve the blood and the gore. They do not involve horrific injuries. And yet again, I must just emphasize, in no way am I undermining those terrible, terrible matters. But those are the cases that make it into the media. But the majority of cases, the majority of violence that women are suffering in this country are not the ones that get into the media. And those are the cases that are simply not getting through our courts. And we have to ask why that is. And with respect to the oversight mandate that this committee has, I really encourage this committee to look at the reasons as to why so many matters are falling out of the system, what we call attrition. Why is it that so many cases are simply not being prosecuted? Why is it that the majority of cases are either falling out at the police level or prosecution level? And although with respect to the National Director, when she was questioned around this a little while ago in an interview, she raised detection as a problem. In other words, that people are not being caught, they are not being arrested. With all respect, most rapes happen between people who know each other. So detection is really not an issue. We have to look at why cases are being discontinued so readily by the South African Police Service and the National Prosecuting Authority. I'd now like to move on to the submissions that we have made on all three of the bills. Because we made submissions on all three bills, the details of those bills are obviously in our written submissions, and I'm not going to take the committee through every single one of those submissions. I've tried to highlight some of the areas that we find are a little concerning. On the whole, we are in support of the bills, and we commend both the department and the portfolio committee for considering these bills and for the drafting of these bills. Yet again, I think that I'm probably repeating some previous submissions where people have said that to a large extent, these pieces of legislation deal with the problem after it's happened. There is a lot of work to be done. I'd also like to circle back slightly to the NSP, the National Strategic Plan, and commend the people that were on the interim steering committee for gender-based violence and femicide. I have many colleagues who have sat on that interim committee, and the consultation processes involved were very widespread. So I'd like to commend that committee on the work that they did on the NSP, and obviously part of the NSP involves targets relating to the amendments to legislation. So that has been done, and I know that I have colleagues on this call as well from the National Department of Justice, and so I'd like to commend them for that as well. So generally we do support, but there are unfortunately a few areas where we do have some concern. Just initially to commend the extension of the use of intermediaries and the use of CCTV systems for non-criminal matters. There's a recognition of the vulnerability of witnesses above the biological or mental age of 18 years. We also support the amendments to what are commonly known as police and prosecutor bail in terms of the consideration now of the nature of the offence and the nature of the relationship between perpetrator or suspect and victim. So we think that it's very necessary that the courts need to take that into consideration, and that police and prosecutor bail cannot be given in circumstances when there is a domestic violence relationship or a breach of a protection order. We also support the codification of inconsistent practice of placing before the court at bail applications the views of a victim regarding his or her safety. And although that is, generally speaking, an informal or maybe even more formalized practice when bail applications are considered in the courts, it's very good that it has now found its way into the Criminal Procedure Act, where there is now an overt and very clear duty placed on the court to consider the view of victims. With specific reference to the amendment of Section 170A, and then that this also then relates to the use of intermediaries in non-criminal matters as well. Although we support the amendment in general, there is concern around a requirement that has been placed into the amendment that says that a witness must so-called suffer from a physical, psychological, mental, or emotional condition before they can qualify for the use of an intermediary. There are already criteria that are required to qualify in terms of, and you'll see that I've said that in terms of the undue psychological, mental, emotional stress or suffering, if he or she testifies at such proceedings. We're concerned about the criteria around this condition. The concern really involves whether that condition is one that must be established through a expert, and whether that must be a pre-existing condition prior to giving evidence, or whether whether it would be considered a condition which would automatically be experienced, I would imagine, by a witness simply by virtue of the fact that they would be giving evidence in court, directly in court, as opposed to via an intermediary or via the use of CCTV systems. So our recommendation is to delete the requirement of people who may suffer from a physical, psychological, mental, emotional condition. I just wanted to highlight the amendment to Section 299A of the Criminal Procedure Act, which is where there is a duty on the court to inform a complainant, if they are in court, of the right to make representations at a time when the accused has served their time and is up for parole, that the complainant may make representations on the placement of parole or correctional supervision. The concern with this provision is actually not necessarily around the amendment, but just in terms of application. The duty exists only on the court, and in practice, it is incredibly rare for a complainant to be in court at the time when sentencing is passed. So we would recommend that duty is extended from the court and must now also be extended to police and prosecution to inform the complainant of the right, because the right exists irrespective of whether the complainant is in court or not. And the problem is that the information simply doesn't continue. Then in wrapping up the amendments in terms of the Criminal and Related Amendments Act, Bill, I'd just like to draw the committee's attention to a national forum on the implementation of the sexual offences legislation, which was held in October of 2017, which was organised and facilitated by the Deputy Minister of Justice, Honourable Jeffries. It was a really extensively participated and consultative process, and there were a number of recommendations that came out of that very conference, where those recommendations have not found their way into the amendments in the Criminal Procedure Bill. And so we would really encourage both the department and the committee to look at the issues of competency around assessment of children, in particular around the taking of the oath, and then also the issues of states to appeal on matters of fact. I'm surprised that those recommendations didn't find their way into this bill, and if I could just encourage the department to have a relook at potentially including those amendments. Then in terms of moving on to the second bill, the Criminal Law, Sexual Offences and Related Matters Amendment Bill, very broadly we support the amendments in this bill as well. There is concern, however, around the new offence of sexual intimidation. There are obviously, as in any criminal offence, there are elements of the offence, and we don't support the inclusion of the element of imminent harm. The offence is basically sexual intimidation where there is a threat to a complainant, where the complainant is inspired a reasonable belief that that complainant may be raped or sexually violated, etc. We don't see the point of of adding the element of imminent harm, and reasonable belief, we believe is sufficient. Then in terms of the National Register, I won't repeat what we support, because I think most people are aware of the general amendments. And so we generally support the extension of the National Register to all sexual offences, if there is a conviction of any sexual offence, in addition to extending the group of vulnerable people. But we must express a little bit of concern around the inclusion of a female under the age of 25. You've heard many submissions over the last few days about this arbitrary age distinction of females under the age of 25, and then once you get to 60 again, then you fall into the vulnerable group as well. So I think the recommendation really would be that if one is going to include females as a vulnerable group, that it would have to extend to females. It would be very difficult to argue that females under the age of 25 are any more or less vulnerable than females over the age of 25. One simply has to look at the statistics of who victims and the profiles of victims are, and it's really across the board, irrespective of age. Then a small thing as well, there is a definition of sexual offence in the National Register for Sex Offenders. We say that it's far too limited, and in keeping with other pieces of legislation, we would advocate that you must include a definition of sexual offences to include all sexual offences, whether it is in terms of statute or common law. One of the more, I think, contentious areas of the National Register is the issue of it being made public. The Women's Legal Centre does not support the register being made public. Without going into the issues of exactly how laws and pieces of legislation must comply, one must always remember that whatever piece of legislation you have, it must serve a legitimate government purpose. And if we go back to why we have the National Register in the first place, it is for the purposes of employment. It is for the purposes to protect people in an employment situation for working with vulnerable people. And we fail to understand what the purpose of making the National Register public would be if it is for the purposes of employment. So we really do, we've argued quite extensively in our submissions around the legal arguments of that, but just to make a statement here that we don't support it and really do support other organizations that have made submissions that it does not be made, that it's not made public. Okay, then moving on to the domestic violence bill. It was a little difficult to know exactly how to put this into the submission, because our submissions really are largely of a very technical nature, and it's around the drafting. In our written submissions, we have included recommendations as to how we believe the sections may be drafted for more clarity and to avoid confusion. But maybe just to start at the beginning around the definition of a domestic relationship, we have some concerns of the added issue where people need to have shared the same residence within the preceding year. We don't believe that that's realistic. You may very well have a situation where someone may have been not living in the same residence for a period of a year. I mean, an obvious example, someone may have been incarcerated for that period of time, they may have been out of town for some other reason, but they still pose a danger. So although they may not be sharing the same residence in the last year, they may still have some form of domestic relationship or have shared the residence previous or prior to that 1 year. So we recommend the removal of that time frame. In terms of a broad catch-all definition of domestic violence, there is reference to other abusive behavior, which inspires or has reasonable belief that certain harm may be caused. We recommend that you remove the word abusive. We find a tautologist. Basically, if there's a reasonable belief that imminent or that harm will be caused, that should suffice. And then in terms of the definition of intimidation, we are concerned about a threat that induces fear of imminent harm. We recommend the removal of imminent harm. It should simply be that there is a threat that induces fear. I think this is also, again, quite a contentious area of the bill. Just to start maybe with the less contentious issues around obligations and on functionaries and other adults around the mandatory reporting. What's a little concerning in the actual drafting of the bill is a conflation and different use of language around the particular standards of knowledge or belief or suspicion, and there's an inconsistent use of that language. And we recommend that two standards would apply to both functionaries and so-called other adults who are aware of domestic violence occurring. And in keeping with the provisions within the sexual offences legislation in terms of Section 54, we recommend that the wording that is used in that legislation is far tighter and probably could be followed more easily. And we look really at knowledge, and the second aspect is reasonable belief or suspicion. So if we could just have consistency there. Then, as you're aware and I'm aware, there have been plenty of discussions around mandatory reporting. And while we have no hesitation in supporting mandatory reporting when it comes to complainants who are children, we really do not support mandatory reporting by functionaries where an adult is the complainant, or where for adult persons where the complainant is an adult. We believe that this undermines the service relationship between the client and provider, and it also undermines women's agencies to make decisions as to the best manner in which to manage the abuse or the domestic violence situation. This really will have unintended consequences of women not seeking assistance from service providers, and secondly, also not from friends, communities, churches, other religious groupings, and because people will be afraid that if they do so, the matter will be reported, which sometimes is totally contrary to how a situation may be managed. I think we have to acknowledge, I think one of the members initially recognized that legislation or bills of this nature are not the panacea. They're not going to solve everything. And for that reason, it's even more important to realize that the law sometimes is not the only and best way to deal with violence. And I think we need to respect that when we have adults involved, they must have agency in terms of making their own decisions. And that follows on from that in terms of the next sections, which is the criminalization of the failure to report. There have been some very good examples that have been given where you may very well criminalize the victim herself as an adult for a failure to report. But I think even more concerning is that you are going to cut women off from the very support that they may desperately need at the time, where they may not yet be ready to go to the police and seek legal intervention from the criminal justice system. Then I'd just like to briefly touch on an amendment that has been made. Thank you very much. I just need to touch very briefly. Sorry? That has been included, and this is the area in which complainants must be told about their results of an application. So I'm not going to spend much time on this either, other than to say that it's a welcome amendment where complainants will be told about the outcome of the application, both in terms of the interim protection order, if it is granted, or where an interim protection order is not granted. And we've made some suggestions around exactly how these processes should be managed in terms of the legislation. We believe very strongly, and systems need to be put in place for applications to be processed on the same day as which they are made. One of the biggest problems is that women are expected to return on further days after they've made the application for an interim protection order. They either have to contact the courts themselves, or they have to make their way to court a second or third time to go and find out what the results of their application is. And this is highly problematic. So we really do ask that, in addition to the provisions that have been put into the current bill that complainants are informed on the day, because the process actually happens during that very day. One other area that we're a little concerned about is the liability that rests on complainants. It's at the bottom of the slide, of a cost relating to furnishing of information and removing of disabling access to electronic communications. Although there is a provision for a requiree to determine the ability of complainants to pay costs, the concern is that there is a presumption that the complainant is liable, and only once she proves that she doesn't have the means to pay for that, then that will shift. That is the end of my presentation. As I've said, there's a lot more detail in our written submissions, but thank you very much for the opportunity for being able to make presentations to you.
Thank you very much. Thank you very much. I must say that this is not the end of our interaction with the organizations that have made representations. I think some of the issues that have been raised are part of our ongoing oversight over the department. And then from time to time, we would be calling upon you to come and assist. For instance, I think 2 organizations, including yours, they have, I think they have shared a good perspective on the issues of statistics, the conviction rates and the percentages and the number of offenses that, in fact, cases that are being enrolled. It's something that we would need to zoom into it as part of our oversight, because the more information that is at the disposal of the committee, the better for the committee to do a robust oversight over the department and its entities. So from time to time, we would call upon people like yourselves and other organizations that have made representations, because we advocate for an active citizenry. Democracy is not only for public representatives. So anyone who can assist us, we would call upon that person to come and assist us in ensuring that we serve our people better. Thank you very much, Advocate. I'm not sure whether the South African Women Dialogue, are they in now?
Yes, Chair, they are in, but they had since requested they've since requested to be last, because they are waiting on another colleague who's in another meeting. So I've engaged Prof to say if she can be next, Chair, and she agreed.
Okay. No, can we invite Professor Skelton?
Chair, it's Werner speaking.
So we had questions.
Are we not engaging?
Oh, hey, no. My apologies. I think it's a long day, Honorable Hon. My apologies. My apologies. My apologies. I will now invite members to ask questions. I have Honorable Mfokeng, Honorable Levo Drachens, Honorable Werner Horn. My apologies. My humble apologies.
No, thank you very much, Chairperson. We understand. And thanks to the Center for the submission. I must say that is one of the best. That is one that is really making somebody to be comfortable. Chair, I just have one question, and it's coming because yesterday there was another, I think, organization that was talking about the register for sexual offenses not to be public. And I had a question from one of the women to say that, tell me, how am I going to know as an ordinary citizen that my daughter who's about to get married is not going to attract a man a man who's been in a case like that or has been to jail and all that. So, and it made me to think, to say that, I'll ask this question. And she gave an example to say, remember, there's a case in UK where a man stayed for 27 years, married to somebody, but that person was not aware that this person is actually being sought by the police because he ran away and all that. And it was on sexual offenses. Thank you very much. I think if we can just help each other and help our communities to lay their fears.
Honorable Mfokeng, I think even for you it was a difficult question, I guess.
It was, Chair, but this system gave me also an opportunity to go and check on the case that they were talking about, and it made me to wake up, to be honest.
No, that's true. It has also shaken me. Honorable Nivot Drachen.
Thank you very much, Chair. And I do also understand, Chair, that it's been a really long few days. So we completely understand. Thank you for the presentation from the Women's Legal Center. In relation to SAPS and the prosecutors, it has been said, you've already said the numbers and the statistics, and we know the reasons about why so many cases don't reach the end of the criminal justice system. So what can be done in terms of all the reasons that we have for cases not going through the entire process? What can be done? How do we ensure that more cases actually go through the entire process of the criminal justice system, and that there are more convictions? And then secondly, in terms of mandatory reporting, we have those who support it, we have those who don't support it. So I would then like to know why women then many women for many reasons don't want to report it. So is it don't want to report, their experience of domestic violence? Is there somebody then who could walk the victim through this experience, to get the victim or the complainant to be ready to report the case? So somebody to hold their hand through, the counseling and all the steps that has to be taken, and then to get them to the point to be ready to report a case, go through the evidence taking, and all of that. And then when they're ready to get the victim to be ready to go to a safe house, maybe having somebody walk the victim through the process, be with the victim, that might help the victim feel more comfortable. It's called victim support. To go through the case. To go through the experience, and we could have less cases being withdrawn. If we could have, what would your comment be on that then, on having that kind of assistance? Thank you, Chair.
Chair, should I go ahead and try to answer those questions, or are there still more questions? Wasn't sure.
Sorry, ma'am. I think there's a technical glitch with the chair.
Okay.
Yes.
I'll wait.
Yes. Now I can. Yes, I could not hear the last part of Honorable Drachen's question. But I hope the presenter heard what the question was. Okay, thank you very much. Honorable Horn.
Yeah, thank you, Chair. Firstly, in respect of the concerns raised regarding the proposed amendment to definitions, I think, as with other presenters, chairs, we must say that we take note of this, but it would also be helpful if alternative wording could be suggested to assist the committee to tighten up the definitions while still giving effect to broadening protection. So that's the one aspect. In respect of the once again, the opposition to mandatory reporting, and the Honourable Niva Drachen, I think, has asked a very good question in this regard. But what I also want to know Ms. Pithy is whether, to her mind, there could be a situation where mandatory reporting in certain circumstances should be applicable. Because ultimately, whilst I think we as a committee take note of the view of a number of presenters of this having a chilling effect ultimately on reporting rather than enabling and enhancing it, I think we as the legislature also cannot be ignorant to the fact that a big part of what is happening, a component of the scourge of gender-based and sexual violence is the fact that sometimes people know about this and the victim is not enabled to report. And then as a consequence, nothing gets done. So how do we strike that balance, if it is at all possible, to your mind? Thank you.
Thank you very much, Honorable Horn. Over to you, Advocate Pithy.
Thank you very much. Thank you very much for the questions. I thought maybe I got away with it, that I wouldn't have any questions to answer, but I'm very happy to do so. Thank you very much. Honourable Member Mofokeng, the issue around the the issue around the National Register and your question that you were asked by someone around how do you then know or ensure that you don't land up in a relationship or in this situation where you spoke about someone getting married to someone who actually was a previous sexual offender. I think we need to look very carefully at what the purpose of the National Register is. And if you look at the legislation as a whole, that whole chapter within the Sexual Offences Act, it is very specifically designed, drafted, implemented for the purposes of employment. If we want to shift the objective and purpose of the register, then we need to be overt about it. Then actually the whole chapter within the legislation needs to be changed and saying the reason we have a national register is not only for the purposes of employment and to protect people from perpetrators, convicted perpetrators from engaging in employment and having contact with vulnerable groups, but actually what we're doing is that we're using it as a means to inform communities broadly about previous or convicted sexual offenders. And those are two very, very different objectives. So we can't at the moment have a piece of legislation which purports to have a register for the purposes of employment and at the same time make it public where that information can be accessed by the public but not for the purposes of employment. So they're two very distinct things. If the legislature chooses to have a national register that is available to the public, then that is what it must do, but with that clear objective. And I think at the moment what's happening is that there's a fudging of two objectives. So in a situation where where you were asked about someone who wants to make sure that the person that they're involved with or the person that they may marry is not a previous convicted perpetrator or sexual predator, actually, technically, they wouldn't be allowed to access that information, which is the situation at the moment. I can't simply go and ask if the person that I am busy dating is on the National Register. I simply can't do that. I'm only entitled as an employer to access that information. And my understanding is that that is the objective of the National Register. If you're going to change it to become a public register, then it isn't only for the purposes of employment. I don't necessarily, I'm not in a position at the moment to voice my opinion whether we should have a public national register. I just think we need to be clearer that if we're going to make it public, it has to be for a particular purpose. And at the moment, the register is very specifically for the purposes of employment and not simply to make it public. So that's the first thing. Then in response to Honourable Members Nivo Drachen's questions around the attrition rates, I think that the attrition rates is something that all of us battle with a lot. And we need to look, unfortunately, at the system as a whole. So my sadly cynical view is that the criminal justice system is a reflection of society, and society, unfortunately, actually only values particular types of sexual offenses, the ones that are the horror ones, the ones that involve a lot of violence. And unfortunately, although we allow and we encourage women to come forward and report matters of rape, what we're actually saying is that we only believe some of you. We only attach value to the experiences of some of you if it is so-called bad enough, if there's a lot of violence. And what we really need, which is difficult, is a massive shift in understanding of the experiences of women around violence. Simply because there is no violent display in terms of blood and gore and guts doesn't mean that someone has not been fundamentally violated. And until we have a system that acknowledges that and recognizes the lived realities of the majority of women who are reporting sexual offenses in this country, we're going to continue to have a 7.8% conviction rate for sexual offenses. So it's a massive shift. And to hide, and I'm sorry, I make no excuses for this, to hide behind the test of a reasonable prospect of a successful prosecution is effectively the NPA saying we know that the courts will not convict this person because that's how the courts have always found it. Well, then we have to start challenging the courts. We have to start putting those matters before the courts, dropping our conviction rates even more and say, well, there's the problem. The problem is sitting with our courts. The courts are too conservative. I'm just saying that that's one way of looking at it. To say we actually have to have a massive mind shift of actually believing women. I could go on about this for a long time. To be honest, I also think that we need to relook at the definition of rape. I think there are a lot of problems around that. But I'll leave it there. And I'm very happy to engage with the committee on more of this. There's a lot of work that we're doing in this area. There's some pending litigation around this that we really want to try and challenge these incredibly low conviction rates. And the fact that really 90% of women and children are being told by the system, we don't believe you. And in terms of mandatory reporting, I understand, and it links a little bit to what Honourable Horn was also asking about around the mandatory reporting. I understand this imperative that we want to make things better, we want to make society more accountable, and we want people to not be silent about violence. I understand that objective, I understand and I support that. The problem is, and I think it may be useful to obtain this information for the committee, there is extensive research internationally that shows that mandatory reporting does not make it safer for women. And that's what we're concerned about, is that we have the benefit of being slightly behind the rest of the world. We have had this kind of legislation in place for 20, 30, 40 years, and we can learn from those countries. And I'm not talking about drawing from the global north only. I'm talking about using it from countries that are comparable to South Africa, where it has simply not worked, where it hasn't helped women gain any more protection. The problem is that if you force a woman into the system is reliant on her to take a matter forward. And if she simply will not participate and assist and cooperate, you're not going to take the case any further. So you'll have a report and you'll have a withdrawal. And then if you move into the next area, which is not in this legislation, but the issue of that you will not withdraw cases, that also creates a situation where women are forced into complying and participating in a system that simply isn't supporting her. I think one of the presenters a few days ago said, we can't insist on mandatory reporting if we're not putting a whole lot of other things in place to ensure that women are protected. Your idea, if someone comes to us with a problem, we immediately refer that person for counseling, for assistance, for support, for all types of information. The more information women have, the more equipped they are to tackle the system and use the system to the best of their advantage. So I think, obviously, in terms of speaking to people, helping them through the experience, explaining the system, assisting the processes, there are lots of organizations. I'm just aware of organizations predominantly in the Western Cape, organizations like Mosaic, who provide an incredible amount of support to women. Don't force them, but very often you work with a woman for 3 or 4 months and then she's ready to go. And then you're going to have a case that's going to stick rather than going in and out of the system. So, Honourable Horn, that does link to you in terms of where you asked if there may be circumstances where it should be applicable. I understand again that there is a concern that we do need to hold communities accountable. People do need to speak out. People need to speak out. They can't turn a blind eye to the levels of violence. We've got to take more responsibility. But I think there's been a lot that's been placed before you about the unintended consequences of mandatory reporting, and it may be useful to continue to engage in with direct service organizations who have a lot of experience on how to deal with these things. I think in a way, and I really mean this with all due respect, I think mandatory reporting is a feel-good option. It won't necessarily result in the results or yield the results that you're looking for in terms of providing more protection for women. I'm very happy to try and facilitate a process from organizations to get you more information around mandatory reporting if it would be of assistance to the committee. Thank you. I hope I've addressed your questions.
No, thank you very much, Advocate Pethy. We are looking forward to your some of the issues that Honorable Horn has asked, some of the text that you might think might be important for us to consider. And that applies to all the organizations, even those people who have made written submissions. It would be important if you feel strongly about a particular wording or a lack thereof that you suggest. It's not mandatory, but we do also encourage that it does assist the process.
So, Chair, if I may just say, in our sorry, I apologize, Chair. In our submission, one of the things we did do was suggest particular wording, particularly around the definition, so actual rewording and redrafting. Thank you.
Thank you very much. Well, I think the question I have, it will be much more relevant, I think, even to Professor Skelton. It was triggered by the issues raised by Honorable Mfokeng and Honorable Nieuwoudt Dragons on the issue of specialization, because we seem to be focusing on the police and maybe the magistrates. Shouldn't we also be looking at the whole curriculum for law graduates or even for law students? Because my view is that the way it is now, it makes people to be hardwired in a particular way. And when we talk about a shift, a serious shift to be victim-centric, to embrace this issue of gender-based violence, it needs a whole lot of a revolution. And I think that if it can be ingrained in the curriculum of even at LLB level, also even at a postgraduate level. I think you might have it at a postgraduate level, but I think the junior degree, because that is the one that is used for admission. But I think you can comment on that, but I think also Professor Skelton, I think that is a question that I think she would need to respond to. Thank you very much. Can we have Professor Skelton?
Yes, Chair, I'm here.
Good afternoon.
Good afternoon. Chair, I'm doing this from my car and I'm using my battery because my time was moved forward. So I do hope that there isn't too much distraction in the background. I'm just going to click the share screen function.
You have 20 minutes, Professor Skelton.
Yes, Chair, certainly. I'll definitely stick to that.
Thank you very much.
So, Chair, I'm based at the University of Pretoria in the law faculty. And as some of the members will know, I've been for most of my career, my entire career, involved in children's rights and in law reform. and I've made presentations in the past to this committee. And also, I've been involved in a number of cases that went to the Constitutional Court. And I only mentioned this because I think it gives me a particular vantage point to see some of the issues within that broader context of the Constitution. So firstly, let me say that I definitely do support the idea that children need protection from persons with criminal records for sexual offences, being able to access them in the workplace. And although I'm focusing on children, I don't have any objection to the fact that the vulnerable categories are being broadened. But I think what we need to remind ourselves is that this is at the moment what the register seeks to do. It seeks to stop people who have criminal records for sexual offences of a particular nature getting contact with children. Now, the bill broadens the number of sexual offences, and again, I don't have any objection to that. I think that that actually in many ways will make the register more workable. And I think that we can see that the aim of preventing people with criminal records from coming into contact with children and other vulnerable people is a very important purpose. And indeed, in the case of Jay versus the National Director of Public Prosecutions, which was about the automatic placement of child sex offenders, in other words, children who commit sexual offences on the sex offenders register, the Constitutional Court looked carefully at the register and said, this does have laudable aims. It does have positive purpose. Although the court went on to find that automatic placement of child offenders on the register was unconstitutional. And of course, this committee then passed Act 5 of 2015, which changed the rules so that children no longer automatically go on the sex offenders register, but can make submissions to court that would, in some instances, mean that they don't go on the register. However, under the current law, child offenders' names do still go on the sex offenders register. And we know that there are at least 200 children's names on the register currently, because when the case of Jay versus NDPP was argued in the Constitutional Court, the registrar of the register made that information available, not the names, but other information was made available. And the Centre for Child Law, who were trying to assist the children, have never managed to get their names off the register. So therefore, we know that they are still on the register. But one of the big arguments that you've been hearing from others, and I won't belabor any points that you've already heard before, is that we actually already have a more effective and more efficient option, and that is the criminal record system, which is under the South African Police Services. Now, as I'm sure you know, when a person is convicted of any offence, so any person convicted of any offence, that goes on their criminal record. And it's automatic in every case, because when your fingerprints are taken at court, when you're convicted, those fingerprints are then sent through to the criminal records database, and it is stored there. And then, of course, at any time, if you or anyone else wants to check what's going on there, that information will be stored there. So by contrast, the National Register for Sex Offences is not so reliable, because although the magistrate or judge must make an order for the person's details to go on the register if they are convicted of any sexual offence, that doesn't always happen, it seems, because it requires a clerk at the court to fill in a form and send it to someone and so on. And we know that there is information missing. And in fact, again, in the case of Jay versus National Director of Public Prosecutions, we wrote to the Minister and the Constitutional Court and pointed out that that was a problem. So I want to just quickly try to compare the problems of the current register and how this criminal record system solves the problem. So I've already explained the difficulty of getting details onto the register. There is also a duplication of registers, because under the Children's Act, there is the Child Protection Register. So the first problem that I've mentioned there is solved easily if we use the criminal record system, because it's already a very established system and it's there. Secondly, it's one complete register, so it can serve many different systems. The third problem with the current register for sex offences is that the registration management process causes certain problems that have an impact on children. For example, if a child is removed from their family because of abuse, and they then have to be placed in temporary safe care, that person has to be checked against the National Register for Sex Offenders, and if you want to foster a child, as well as the situations of employment. And when child and youth care centres want to employ someone, what we are hearing is that there can be many, many months of delays before you actually get a response on the National Register for Sex Offenders. The other thing is that the category of crimes captured on the register is still too narrow because it only picks up sexual offences. So if you wanted to know whether the person you're thinking of employing or having as a volunteer has committed a violent offence in the past, this you cannot tell from the sex offenders register. We've also seen that the National Register for Sex Offenders has in respect of past offences has been very problematic. So the Act actually requires that not only going forward would people be put on the register, but people who are serving sentences and people who had criminal records would also all be put on the register. And this process was never completed because it was so difficult to identify them in the system. Now, the criminal record system is inherently historic. Once you have a criminal record, it stays there until your criminal record is expunged. And in some instances, your criminal record is never expunged. And then lastly, the register raises certain constitutional questions which are exacerbated by the bill, I would respectfully say, especially with regard to the retrospectivity problem. So in other words, if you committed your offence 10 years ago and you didn't know that your type of offence would go on the register then, there is what we call a rule of law difficulty with something like that. But interestingly enough, if you got a criminal record 10 years ago, you know that that criminal record is going to make it difficult for you to get a job. So you're not learning anything new now or not having a particular disadvantage now if the law said that your offence is now going to be one of those which, if you have that conviction, you can't be employed. Now, some of you might be wondering, okay, well, we've heard this from a few different organizations, but is it possible to make this change in this bill? Because it might seem like quite a big change to make. Now, there are some specific amendments that need to be made to section 41 and 45, and in the next two slides, I'm going to quickly show you what they are, and they are in my PowerPoint, in my written submissions. There would also be some consequential amendments that have to be made to other sections of the bill, and the state law advisors would need to do those. So I think it is doable, but in this bill, it may be that it has to be limited to sexual offences. And I've talked about the benefits that the broader register could have to pick up other types of violence. But maybe then that would have to be part of a broader thinking process to see whether we can broaden it in the future because of the fact that this is the Criminal Law Sexual Offences and Related Matters Amendment Act. It probably needs to be limited to sexual offences here. But of course, this bill will make that all sexual offences, which I don't have a problem with. So what would the amendment to section 41 look like? You can see I've put in red the words that would need to change, and then certain words need to be taken out. I'm not going to pause on it for too long, but it's simple. A person who has a criminal record of a sexual offence. And then the next one is any employer who, at the date of the commencement of this chapter, has in his or her employment any person who has a criminal record, that person, the employer can require any employee to produce a police clearance certificate, and from the date of this chapter cannot employ any new person because they can require them to produce a police clearance certificate. And then at the bottom you'll see must not employ, shall not employ an employee who has a criminal record for a sexual offence. I've put in there blue. One could also say, or a violent offence, but as I pointed out, this might be difficult in the context of this particular bill. So, and then, as I mentioned, there would be some other consequential amendments. But as you can see, I don't think it is that massive a thing to do. I'm moving on now to the second main point that I want to raise, and that is that I'm joining the voices of those who say that the proposals for making the register are, I think, very problematic, particularly the way that it is done in the bill. I think that, for example, this provision was not included in the bill that the department put out for public comment. So we who had commented on that bill had not seen this before until this bill came to Parliament. That suggests to us as a sector that it was put together rather hastily, added at the last minute, and I think you've heard some submissions that point out that it doesn't fit with the rest of the Act, because the Act talks about confidentiality of the register, how one applies to the registrar to get the information. All of that will just make no sense at all if the details are on a public platform, but unless there's some other meaning. But as it stands now, it would seem to contradict the purpose of the register as it appears in the Act currently. The other thing is, we must understand that this whole register links to an automatic placement on the register, and there is no discretion for the courts, and every offence category is included. So whether the offender is a 40-year-old rapist with a previous conviction for rape, or an 18-year-old who had sex with his 15-year-old girlfriend, and therefore it's statutory rape, even if it was consensual sex, all of those people currently would go on the register. And now far more will go on the register because of the way that the offences are being broadened. And just think for a moment about what that means to a register that is already not very effective and not very efficient, as well as the fact that the number of vulnerable people is also being broadened at the same time. I must inform you that in the case of J versus NDPP, the Minister of Justice's Counsel conceded that the automatic placement was unconstitutional regarding all offenders. However, the Constitutional Court decided only to declare it unconstitutional regarding child offenders. And that was because the case was about a child offender. So I believe that there are some risks that this public register, if it were to be passed, particularly the way it is now in this bill, could be unconstitutional. The way that the current law makes sense of these difficulties of constitutionality and this fact that all offences go on the register is that they say that the longer your person's sentence is, the longer that person stays on the register. And as you know, another piece of legislation is extending the length of time it's the same legislation, a different section, is extending the amount of time one stays on the register for. But I just want to make the point that if it is a public register that anyone can go and search and look at and click on a name, then it doesn't really matter if you're only 5 minutes on the register because it's a public register. So in a sense, it becomes a permanent register. Now, I've said already that our criminal record system is a permanent record system, and it is, but of course it's not a public record system. But employers can call for it. They can put the responsibility, in fact, on the offender to go and bring their police clearance certificate. We've all worked with police clearance certificates. We know how they work. We have trust in them. And that actually could, in my view, work better. So the difficulty with the public register is it's a permanent register for everyone to see, whereas the criminal record system is a permanent register that you can structure how you want people to have access to it. Another risk is the lack of an evidence-based approach, and I think I've heard other presenters talking about this as well. Why is it important? It's not just because I'm an academic and I like evidence that I think it's important. It's because if the law is challenged in the Constitutional Court, the court will have to decide, is this public register, this provision for a public register, is it logically connected to its purpose? And so perhaps the reason why it's there is to enhance the safety of potential victims. We don't know what the purpose of it is, but if that is so, then we'd have to know that there was evidence that having access to a public register increases the safety of potential victims. And indeed, there is no evidence that that is the case. The court would also ask, are there less restrictive means that would achieve the purpose? And indeed, there are less restrictive means, such as the way the register works now is a less restrictive means, and using a criminal record system in the way that I have proposed would also be a less restrictive means. So I think that the evidence base is important because it will be difficult for government to defend this legislation in court without that. And then if the law is then found unconstitutional and the names are already on the register, clearly there is no way of going back at that point. Other concerns then, well, the majority of sex offenders are known to the victim. This is particularly true of child victims. They're not strangers that have to be identified through a list. And in fact, there is some evidence that it creates a false sense of security to think that offenders are all on a list somewhere when they could in fact be in your house and they're not on the list yet because they haven't yet been caught. Children also live in households where there are sex offenders, and a public register will also expose them to risks. Currently, for example, we don't publish the names of sex offenders. If, for example, a man rapes his own daughter, we don't publish his name to protect her. That's a long-standing protection that we've offered under our law. Well, it would have no meaning if his name was then to be made public. And I know that this is a difficult one to get one's head around because you feel like, oh, but he shouldn't be protected. He especially shouldn't be protected. I feel like that too. But we've got to think about the realities of living on after the aftermath of the offending. And then, of course, there is the vigilante action risk. And there is evidence in other states where public registers are used that there has been vigilante action. And I think that this is a real risk in the South African context. To conclude, I will refer the committee to the detailed proposals on all aspects of the bill that I've made. I'm not going through all of them here. Most of the problems that I've raised would be resolved if the state uses the criminal record system instead of the National Register for Sex Offenders. And I believe that far from being soft on perpetrators, this would in fact be far tougher. It would be more efficient. It would be more effective. It would be easier to administer. It would be more cost effective. And then the funds used for that could be freed up and rather taken
Prof, are you there?
Good day, Chair.
Sorry?
I'm saying good day, Chair. I think the prof has been cut off by issues of network, Chair. Let me try and get a hold of him. I'm sure she'll try and connect again.
I've also been experiencing serious challenges with network on the site.
She's joining as we speak, Chairperson. I've just accepted and opened the waiting room for you.
Okay. Sure.
Yes, Chair. I'm sure she will come. She's in now, Chair. Thanks.
Okay, sure.
Hello, members, Chair. Sorry. Good day, Chairperson.
Yes, Mr. Mtanjeni.
Chair, I just got off the phone with the prof now. She is trying to dial in, but seemingly that's also a problem. So her battery, as she has informed us earlier, that she's on the road. So her laptop battery died and she can't get to a charge in the next 30 minutes to an hour. So for now, I think she's suggesting two options that she can avail herself for Tuesday, then for the engagement, and then or members can send written questions, then she'll respond in writing as well. She was just proposing that, and she's waiting for the chairperson's direction with regards to that.
I think members, because she was concluding already, and she has given us a detailed submission on her side. I think because written submissions are also, as we give equal weight, shouldn't we be, unless members wanted to ask specific questions, but shouldn't we just go for another presentation? I don't think that we should be extending this until Tuesday, because we also need to give the department time to go through all these submissions so that they can be able to respond to them so that we can start processing again. She was really, in fact, she was making her concluding remarks. I'm not sure what would be the view of the members.
Okay, it's a pity that the Professor Skelton, the connectivity, and it's wonderful to hear. I've known her for many years, but I do understand your constraints in time, as far as time is concerned, and so I would support your view that we've got a submission, and maybe if there's any additional points you might want to make in writing, it'll be fine, and we can engage with her if necessary. But I think that we need to move on to the next presenter. We've got very limited time, so I support you in that regard.
Thank you very much.
Thank you. It's a pity because I know Professor Anne very well. Would have liked to engage with her, but I just also wanted to thank her for her work. Thank you, Chair.
Thank you very much, Honorable Swart.
We agree.
Thank you very much, Honorable Mpuke.
We also agree.
Thank you very much, Honorable Breitenbach. I think let's move to the next presentation. Is the women, South African Women in Dialogue, ready now?
Yes, sir, we are ready, Chairperson.
Oh, thank you very much. Thank you very much. Your slides, can you be able to fly to them? Or do you have
yes,
slides?
Yes, colleague who will do the slides for us.
Okay.
Ms. Maima Keketo will speak on our behalf, Chair. Thank you.
Thank you.
We just want to thank you for understanding. We were supposed to have come on Tuesday. We had a bereavement of one of our board members, and we had a funeral, Dr. Mahlati. And so we really thank you for your understanding and for the opportunity. I'll hand over to her because of time. Thank you. My name is Togo Mpumlwana, the chairperson.
And our condolences to yourselves and to Dr. Mahlati's family.
Thank you, sir.
She has always been a dedicated South African who served our country well.
Thank you. Thank you.
Thank you very much. So are you ready to fly to slides?
Thank you, Chair. I've just requested Mtonjeni to assist me.
So we will give you 2 minutes. Can we start at 2:10?
Okay. Thanks, Chair.
Thank you very much.
See ya.
Yes, ma'am.
Okay.
Let's see. Are you able to see that?
Yes.
Okay, I will just request you as you move just to say next slide, so that.
Okay. I hope I don't forget. All right.
Yes.
Thank you very much. Thank you.
We'll start at 10 past then. Thanks.
Okay.
Almost all these dogs do not like these discussions.
This time it's not mine.
Yeah.
So yours has been won over now, and it now understands the importance of these discussions.
All three of mine are fast asleep.
No, thank you very much. Over to you.
Thank you very much, Chair. Am I audible?
Yes, you are.
Thank you very much, Chair. As it has already been indicated, my name is Keketso Maema. Chair, the Chair has already indicated that we thank the Portfolio Committee for making time to engage with us on this very important process. Chair and members, as you would know, SAWID, as is often known, is an independent, impartial, non-profit, non-partisan organization that is committed to improving the status of women by engaging national government, the private sector, civil society organizations throughout, whether it's NGOs, CBOs, and faith-based organizations, and forming partnerships that will shape developmental agendas and respond to issues that affect women in the main, socially, economically, and otherwise. And so when the Department of Justice had, run around as quickly as they could, which we also recognize, in ensuring that they come up with these bills in light of, the processes, the bigger processes that have happened, the declarations, the summit, as well as the processes that led up to the NSP. Now we are here, they've come up with these bills. In line with our mandate, we then decided to hold a number of webinars, Chair, where we engaged women from all walks of life, because it was important for us that whatever document that we put before this Parliament is a document that has gone through and engaged with women on the ground. We have put in about a 36-page document, Chair. I will just try to be very quick in terms of highlighting the issues. The written submission is there, and I hope not to waste too much time, Chair. Chair, I will start first by highlighting the general observations that we have. If you look into the preamble, and specifically on this preamble that we are talking to here is the one on the domestic violence bill. It has highlighted the purpose of the bill as a way to afford victims maximum protection from abuse. And one of the things that has been introduced in this particular bill is to ensure that all the other relevant organs of states give full effect to the provision by ensuring that everyone
within the state that has got a stake in this particular bill forms part 2. And as much as we appreciate that, Chair, we would also want to just highlight that we would want this to caution that we don't find ourselves having issues of secondary victimization. Chair, even with the Principal Act as it stands, we are aware that a lot of institutions having done monitoring work, there has been indications of the fact that there seems to be secondary victimization that then happens when people visit, whether it's SAPS and all the other role players. And so, as we are happy on the one hand with the fact that all the other relevant departments will be party to this directly, but we would also want Parliament, as they pass this law, to really ensure that issues of secondary victimization are addressed, and that we won't find ourselves with those particular problems. And so we had proposed, Chair, that with further sectors having been included and given responsibilities, that the issue of training and skilling should really be prioritized. And further, we would want to see some protocols or some guidelines or norms and standards that should be put in place, in fact, prior to the Act coming into effect, Chair, so that at least we hope it will be able to assist to alleviate previous issues that we had with the Principal Act on secondary victimization. And we recognize as well, Chair, that functional literacy is important. When we had this particular engagement, Chair, we tried to also include some of the magistrates and some of the colleagues that are directly involved with this particular work. And some of the colleagues that we were engaging with were very, we did highlight the importance of ensuring that we have people that are able to interpret and have knowledge of these pieces of legislation as we put them in place. A lot of times, Chair, when we have these kinds of legislations, the clerks that assist ordinary women when they get into courts, we take it that it's okay just to have somebody that just has a metric, for instance, somebody that will be able to assist. But what we found as we were engaging Chair and members with some of the presiding officers specifically on this, they have highlighted that it's going to be quite important that we get people that understand where we are coming from as we are putting these pieces of legislation, people that will be able to interpret so that they can hone important information out of the complainants. Because a lot of times, some of the magistrates, for instance, they were saying on domestic violence matters, when by the time that the files are before them, they can already see loopholes, but it becomes quite difficult, for them to be able to do this work. It was quite interesting, Chair, that even some of them were saying, shouldn't some of us as magistrates actually be doing this particular work of completing some of these documents and the like. But we felt that we will just highlight it here to say in our recommendation, we are just going to highlight that it is quite important that the clerks and even some members of the SAPS, of course, because they play a very crucial role as far as this process is concerned, that they should be informed, and it must be periodic, because a lot of times we think that a once-off engagement and all that is okay, but we need to have people that have the knowledge that we need to be victim-centric in our approaches as we deal with this particular work. The next issue, Chair, that came up is very sharply was the issue of resourcing. The fact that we never, resource our legislations properly, and so it is important that we ensure that whatever that we do everything is properly resourced, taking into account the vulnerable communities that we want this implementation is going to be quite important for them. And so one of the things that we had then thought would be helpful, Chair, we had tried to do it. We had tried to also have an engagement with the departments that are listed under Section 18B, if I'm correct, but that could not happen. And so one of the things that we thought would be important is to just request as well Parliament to say, as you engage on this, and before you pass this particular law, it may be important to also engage directly, Chair and members, with some of these departments that have been mentioned, so that it's not just the DGs that engage, but Parliament must satisfy itself that actually everyone is ready. State of readiness is quite important, but also to ensure that they have been able to cost some of the responsibilities that are coming with this particular amendment properly. And Chair, I think we did try to log on. For instance, we had, for instance, the presentation that was coming from SAPS and the kind of things that they were putting forward. And from where I was sitting at that point in time, it felt quite important that we actually, highlight this particular point, Chair, of state of readiness, engaging in all the departments that have been highlighted in the bill, just to ensure that everybody is actually ready and that the work will be done. Second slide. Other general observations that also touch on all of the bills, Chair, is the issue around binary language. In our engagement, we also had LGBTIQA plus communities, Chair, and what came out very clear was the fact that the language that is used in terms of defining some of the terms really needs to be inclusive of this particular community. And so we have recommended their Chair, having engaged with them, they were very clear that as we look into the different sections, that there must be a proposal that requests that the drafters of the bill to consider language that is inclusive to all vulnerable populations, and that in some of the sections, instead of just saying he or she, that we take cognizance of the fact that we should include he, she, them, and they, because that's the kind of language that would also be inclusive as far as they're concerned. And there were other recommendations, Chair, around issues around signed language at courts and the like, at a point, not just at a point when court procedures are taking place, but as well at a point where clerks are assisting and picking up some of the work, some of the complaint, or engaging with some of the complainants. In the bills as well, Chair, generally, we've seen that there's quite a number of discretionary language. And during our dialogue, we had to discuss, weaknesses and challenges of the Principal Act, obviously. And some of the presiding officers had indicated, for instance, that there are sections that are giving quite a number of discretion to police. And even in the Principal Act, there were issues. Section 8.4 was a point here to say that a lot of times there will be a discretion. A magistrate would actually give maybe a warrant, and then the next thing, there is a section that then says a police officer can, exercise some sort of discretion whether, you must arrest or not to arrest. And so having had those particular problems lifted in the Principal Act as far as Section 8.4 was concerned, we felt that it's quite important, because as we saw throughout, there is language that also still gives some discretion to a greater extent to peace officers in the bills, Chair. So we just wanted to just highlight to say it may be important that we actually limit, the language that gives those discretionary powers. In looking into the domestic violence now directly, Chair, one of the issues that we had, and I know that this point has been really belabored because I think a lot of presentations that sister have had have highlighted the particular issue around this imposing duty to report, Chair. And like with other institutions, we are quite happy that we have something of a duty to report like that against a child or persons with disability, and we welcome that as far as that is concerned. But as far as B is concerned, which extends it to adults, we have a little bit of a concern, Chair, and this we take it because as part of the processes, I mean, the Commission for Gender Equality in December 2019 had held a dialogue with various victims of violence. And at that point in time, one of the things that they were trying to look into was the issue of attrition. They were trying to see what is happening, with some of these cases. In fact, we were using, one colleague of ours who is quite a professional, who then at some point decided that she's going to then, withdraw the case. And we wanted to understand, because a lot of times at the time, we would forever think that it's circumstances, it's financial, because you are financially reliant on the person and the like. But when we were engaging with this particular person, we actually found out that it wasn't the case. And that then culminated into having that particular process. And a lot of victims of violence were very clear to say, what does justice look like? And who determines what justice is? Justice is personal. And what might be justice for one person might not necessarily be justice for another. And so society must never take away the woman's freedom to choose, because that in itself is a form of violence. I'm quoting directly in terms of some of the things that were highlighted by victims at that point. And so on the basis of that, we felt that it may be important, and we do have some reservations as far as mandatory reporting is concerned as it relates to adults. Because we don't want anything that may take the autonomy or the agency of the complainants away. We do understand, the fact that the frustration, Chair, of what needs to be done. Yes, Chair?
You have 5 minutes.
Okay, yeah. We do understand, Chair, that this particular section was trying to deal with issues around bystanderism and the like, but it may just be important that we relook. We are quite happy with the online applications, Chair, and we commend this particular move. A lot of work that have been done around GBV has made it very clear that availability for data is not there, and we're hoping that this central repository will also assist us in us being able to have data that will help. We have also highlighted, Chair, to say the online applications, we hope that they will also take into account, and the translations into all the official languages must then also be looked into and be taken into account. There is a lot of literature, Chair, when it comes to variation of protection orders that advocates for not allowing, complainants to withdraw. And whilst there are other school of thoughts, obviously, that then wants to balance that with the agency for women. So in order, for us to balance this, as far as withdrawals are concerned, that we do recognize that the court must be able to probe further and look into, satisfy itself before, they can change or withdraw these protection orders and the like, Chair. As far as the offences sections are concerned, we would propose Parliament to explore the possibility of adding issues around restorative justice elements, Chair. I think, and we have highlighted this even under sentencing and the like, there may need to be a balance. We know that these particular legislations are not going to be an assistance to deal with all the problems. And so we shouldn't forget issues around restorative justice, and we would want that to also be looked into, Chair, as far as that is concerned. Now I'm under pressure. We have already indicated the issues that we had under Section 18A and 18B as far as the state of readiness is concerned. We know that the newly adopted National Strategic Plan highlights the needs for multi-sectoral approach to eradicating gender-based violence and femicide. And we recognize that even in some of the international instruments that we are signatory to, specifically CEDAW, that this particular move has forever been put forward. But as we indicated, we would like to have something that actually looks into ensuring that other departments that have been mentioned are also ready. Chair, we also, in our engagements, there were a lot of people that were highlighting and wanting to check how come the Department of Corporate Governance and Traditional Affairs was not, also part of the, departments that have got directives that are under the Section 18 directives, taking into account that, they are local municipalities are under them. And when you look at the structure in terms of, the current plans in responding to gender-based violence and femicide, when you look at the NSP and when you look at the strategy that is being taken by the Department of Women, you can see that there's also a layer where they would want local municipalities to really be involved. And so we also thought that maybe the NSP, which presupposes that there's inclusion of local government for integrated planning, that perhaps it's something that we can also look into in terms of whether shouldn't we have COCTA also highlighted here. I will finish very soon, Chair. I won't repeat some of the issues that I've highlighted. I'm just trying to go through as quickly as possible, scan. I think that the main issue, yes, Chair, the main issue that we also wanted to have our voice highlighted is on the National Register of Sex Offenders, Chair, and specifically when we look at the fact that the vulnerable groups seem to exclude, survivors of sexual violence. Our suggestion was that we must be able to cure this defect, Chair, perhaps go into the definition section where survivors of sexual violence will be included in the listing of vulnerable groups. But further, we also wanted to propose that the restriction that is included in this proposal to the effect that persons who are vulnerable are just only people that are age 25, that, Chair, that also be looked into. I think, Chair, that I will end there. We have highlighted, we have tried to really highlight in our presentation, but as well in the actual submission, the recommendations that we are doing.
Ms. Mayema?
Yes,
please,
Chair.
Please, thank you very much. If we'll start not respecting time, then we will run into problems with other organizations. Please. Thank you very much. I will now allow members to ask questions. I have Honorable Mfuke. I think it's only Honorable Mfuke. Can you ask your question, Honorable Mfuke?
Thank you, Chairperson, and thanks for the presentation from South African Women in Dialogue. Chair, I just wanted clarity on the issue of withdrawals. It seems as if they have done a lot of work, and I wish that they can actually talk to us about it, because withdrawals are done in court and some of them in police stations, to tell us that what should we do in future, because some of the people that withdraws the case now and then, and even experience has shown that most of them at the end are killed. So if you can help us, what do we do when situations are like this? I like the way you on the military challenges, that somebody, we will look at that as the committee as we deliberate. Now I want to check on the last part of the costing. I heard you saying that departments that are related to this work should start looking at the costing. I don't know if you are aware that the steering committee reported, some of the people that are sitting in the steering committee, like those of the Wise for Africa, they are saying that the costing was done. It's 8 million, it's 8 billion, and the 1.6 billion was only for 6 months to do what we are doing now. Can maybe I get a clarity that you need the recosting or you were not aware? Thank you, Chair.
Thank you very much. Any other member before I allow Ms. Mayema to respond? No other member. So over to you, Ms. Mayema.
Thank you very much, Chair, and thank you to Honorable Mofokeng. We would definitely, if needs be, engage Chair and members on issues around withdrawals. I think this particular matter is a delicate matter that needs a balance. Because there are, those victims that feel very strongly in terms of wanting to take their own decisions and have their own agency. But in the same token, we do take into account the fact that there may be those people that actually want to be assisted, that would want somebody to take up the matter on their behalf. So it's quite something that we need to look at very, very closely. I mean, if needs be, if we need to do, a write-up, I think, Chair, I'm also, the point is I also have just left the Commission for Gender Equality, and we did quite a lot of work even there as far as attrition is concerned, and I'm hoping that I wasn't part of their presentation. I'm hoping that in their presentation, they would also spoken to issues around attrition, because I think it's something that will assist in this particular process in ensuring that we do strike a balance. We want to be victim-centric in our approach as we do this particular work. And so it's going to be important that we look from both sides. As far as the issue of costing is concerned, I'm aware that costing has been done at that level. I was part of the interim steering committee as well. However, I think it's important, from departments. I think what I'm trying to drive at is much more the issue of ensuring that they are ready, capacity-wise. There are responsibilities there are new responsibilities that have been given to some of these departments in this particular legislation. And I would want us to ensure that everybody is ready. It's just holistically capacity and resourcing and skilling and all that is going to be of importance, that we would want to engage with these particular departments just to make sure that everybody is ready, because otherwise we are going to still go back to the same old, where we have, some of the pieces of legislation that we are unable, to move some of the work forward or implement properly, because there are some, departments and some others that are part of the process that are lagging behind. So it's just from that perspective, Chair and members.
Thank you very much, Ms. Mayema. Thank you for the presentation. We know that you have a detailed presentation that we will go through it, a written one. All the issues you have raised are going to be taken into consideration when we deliberate on the bill. Thank you very much for for your attendance as the organization. Thank you very much.
Thank you, sir. Thank you.
Thank you very much. Honorable members, seemingly the Western Cape government is not available for today. I'm not sure how we should treat that because generally the plan was to finish today so that we can allow the department to start compiling all the responses. Also bearing in mind that quite a number of members would not be available from next week. Some are writing, some are attending to congresses, and some are attending to the Intelligence Committee. But also I would like to be guided by the committee. What do we do with the Western Cape government? Because they were supposed to come today, but seemingly there was a communication breakdown. Honorable members, Honorable Mfuke.
Chair, I want to suggest that maybe the secretary should communicate with them and check on how are they going to be doing that now that we are about to be finishing. Are they going to be comfortable with maybe taking them as written submissions or what? Because now we don't have any other time. Next week is out. So I want just that maybe we give it to the officials to go and check in also to indicate the challenges that we are having.
Okay. Thank you very much. What is the view of other members?
Chair.
Honorable Nubot Drachens.
Thank you, Chair. We are still going to do the DPP's report, right? So I'm wondering if we can maybe just suspend the public hearings, go to deal with the DPP report, and at the same time the Secretary can contact the Western Cape government just for a final time, and if not, let's at least then we'll be finished with the DPP report while we wait for them to check, and if there's no availability, then we must accept them as written submission.
I think that is the most practical one. Can Mr. Mtonjene contact the Western Cape government and see what their response is? And then I think at the same time, I think let's do the DPP report. I am informed that the report was circulated to members. Can I get a confirmation if the members have received the report?
Yes, we did, Chairperson.
Yes, Chair. Chair, can you just give me 1 or 2 minutes? Let me just look for it. It's on my other device. Just a few minutes.
Okay. Honorable Breitenbach. Honorable Breitenbach. Honorable Horn. can the report be flighted? Because I'm trying to get. Oh, this is the draft report. That is good. Because I was struggling to find it in my emails. Can you flight the report?
Chair.
Mama Seko?
Thank you, Chair. Can you just brief me now? Where are we? Because I just my gadget just went off power, and then I'm on another one. So I hear you talking about the report. Can I just get a small explanation as to where we are now?
Okay. We had a challenge. The government of the Western Cape is not available today. So
Okay.
we asked the Secretariat to contact them. And then as a result, we have briefly suspended the public hearings. We will be dealing with the report on the approval or consideration of the salary of the Deputy Public Protector. And then after that, we will go back to the public hearings and hear the report from the Secretariat as to what is the feeling of the government of the Western Cape.
Okay, Chair. Thank you, Chairperson.
Thank you very much. Let me check. Is Honorable Bredenbach present? Honorable Horn?
Honorable Horn's just unavailable for the moment, but I'm here.
Oh, okay. I'm trying to calculate the quorum because we must make a decision.
Okay, I'm sorry. He's just stepped out for a moment.
Oh, okay, but she's coming back.
Yes, he'll be back shortly.
Okay, thank you very much, Honorable Bredenbach.
Okay.
Honorable members, the report has been flighted, and I'm advised that everybody received the report, and we have gone through it. But what I don't see here, is it the increase, is it retrospective to the date of the appointment?
Was in the previous report.
Hello? Bonani? Who is flighting the report on the screen?
It's me, Chair.
Okay. I don't see is it from the date of the appointment?
Chair. Chairperson.
Hello.
Hi, it's Christine here. On the issue of the backdating, the President's recommendation doesn't have a date, but the DP was appointed on the 1st of February this year. So I wasn't too sure whether we could include that as our recommendation, backdated to the date of her appointment, but it's not actually as part of the determination.
Let me hear the views of other members.
We reserve our views on this matter, Mr. Chair.
Honorable Peter. Okay, thank you very much. Other members, Christine, will it be illegal if it is from the date of the appointment, the increase is from the date of the appointment?
I mean, that's a legal issue, so I wouldn't, yeah. I'm not, I don't know if I can answer that. I don't want to give sort of legal advice that's incorrect.
Okay, here is the report, members. Firstly, let's first deal with the text and the corrections before we put it for adoption or not adoption. That is a consideration. Are we happy with paragraph 1?
Oh. Is it, are we flattered that one? Speaker did it. Yes.
Yes, Chairperson.
Yes, Chair.
Okay, paragraph 2.
Yes, Chair.
Paragraph 3.
That's what it is doing. Yes, Chair.
Paragraph 4.
Yes. Yes, Chair.
Paragraph 5.
Yes, sir. Yes, Chair.
Paragraph 6.
Yes, sir. Yes, Chair. I think that one also.
Yes, Chair.
Paragraph 6, paragraph 7.
Application. Okay.
Paragraph 8.
Yes, Chair.
Paragraph 9.
Yes. Because explain what we know. Can we go down again so that you can finish that paragraph?
That is paragraph 8.
Yes, it's supposed to be 9 because it's long.
Okay, let's go to the long paragraph.
Yes, Chair.
Paragraph 10.
My recommendations, yes.
Yes, Chair.
My proposal, honorable members, I still think that maybe we should refer this to the parliamentary legal advisors to check if the retrospectivity that is effect from the date of appointment, the increase from the date of appointment, that the difference be paid from the date of appointment, whether that would be in order, because we are trying to make a correction of what we thought was, in fact, I think the president letter is trying to correct what appeared to be an injustice, and the injustice happened from the date of the appointment, because the salary that she received from the date of the appointment was not the same salary that the previous deputy public protector received. So I think if that is not addressed, let's get a proper opinion on that, so that if it's possible, we include it. If it's not possible, then it's fine.
Chair,
Honorable Maseko Chele.
I think I will agree with you, though. When the procedure, obviously, because we are correcting something that should have happened at the beginning when we employed her. I think let's get the report. I agree with. Let's get the advice from the legal. But I think my view was going to be it was going to be, it has to start at the beginning, though we understand, because I know that some of the things that may be a problem, it is this issue of the status of our economy where we are. That can be maybe an issue that can be raised, but also fairness, it has to be considered because she has done the work from the day when she was employed. But I agree with you, so that we exhaust all the avenues. Let's take it to the legal advice of Parliament. Thank you, Chair.
Thank you very much.
Align myself with the Honorable Maseko Jele, and I'm saying that it goes back to the legal department. They should be coming back with a clause that says exactly that, because at the moment it's not there, and we agree that it was supposed to be from the beginning of her employment.
Thank you very much. Any counter view?
Well, I don't know, Chair. I was of the view that we are saying we support this report. I didn't get anybody who was not supporting it. We support the report, and therefore we refer it, and basically subject to further legal advice. I don't expect that we still have to want to have this coming back to us. It's deepening further injustice, unless there are issues that was the point you have raised. It's a legal clarity whether, given many of the issues that have been there. So otherwise, there would not have been a point for us to discuss this before it went. So I'm trying to suggest a process that we do support, but we will take it for.
Okay. No, I would suggest, Honorable Judge, just to be cautious that we don't know what the legal advice would be. That once we have received the legal advice, let's put it again to the committee for the final adoption. Let's be strict with time. Yes. It's a matter that is very urgent. Would want to process it as soon as possible. So let's get the advice, then would generally with the advice, then would put it to the committee for adoption.
We agree, Chair. Thanks.
Thank you. Thank you very much, honorable members. Can we go back now to the public hearings? Do we have anything from the Western Cape government? Sia?
Yes, Chair.
Yes.
Chairperson, we have been trying to contact them. We have not won that side yet, Chair. But we've since sent them communication, which we would wait for their response if to find out when would they be available, Chair. But however, Chair, as you've indicated, that today was our final day because we have a full week and we don't have enough members for next week. So I will engage with yourself after the meeting, Chair, and find out how can we go forward. But we haven't got a response from them as yet.
In light of the above, members, what do you suggest?
Chair, we had a suggestion that I think Honorable Velma said the same thing that I said, that maybe we should check with them. If they are not available today, then we'll have to send it to the submissions, the written submissions.
Okay. Thank you very much. Honorable members, are we happy that we treat it as a written submission?
Yes, Chair.
Honorable Bredenbach?
Mr. Chair, I don't know, were they aware that they had to be here today to present?
Everybody was contacted, but the Secretariat can answer for themselves. I think everybody was here, was contacted about the time and everything, but let's check with the Secretariat. Mr. Mtonjeni?
Chair, communication was sent to everyone who indicated that they would want to make oral presentation. But I must state it up front that seemingly from our side, there's been a mistake where we have sent the information to a wrong email or in the side of the Western Cape government. So this morning when we followed up with them, they indicated that we have not been sending the information to the right email addresses, and they were then requested us to invite them formally for oral presentations, of which we did. That's the response we were waiting for, Chair. So there's been a mistake from the side of the Secretariat. We apologize for that inconvenience, members.
Well, you know, Mr. Chair, then clearly they weren't invited to present.
Yeah, no.
And if you can hardly say that you ask a provincial government to present at some time during the morning and tell them they've got to be just after lunch. You know, people have day jobs. There's no point in playing a blame game. It's an honest mistake. But then they were not invited to present. So then we must either try and accommodate them, or we must accept that we didn't invite them, and accept it as a written presentation. But it's no good saying they were invited to present when they weren't.
Honorable members, I think let's do it this way. Let's look at the Wednesday, how many members are available, because I do think that we would need to allow them to present.
I'm available, Mr. Chair, and that's a very admirable attitude, and I thank you for it.
Let's allow them to. I think on Wednesday we are, because we're not available on Tuesday, and then other members are not available on Friday. I think the DA is not available on Friday. Honorable Masego Jail is not available on Friday, but I think on Wednesday we are available. Let's do the right thing. Let's allow them to present on Wednesday.
At what time, Chair?
I think that is the. I think let's start at 10. Let's start at 10 because they'll be the only ones. Let's hope so. I think they'll be the only ones because we have covered everybody. And then I think because Professor Professor Skelton also had that particular challenge. I think we should extend that even to her, so that if members still wants to engage with her presentation, they can engage with the presentation. Let's say that is on the Western Cape government and Ms. Skelton.
We agree, Chair.
So it will be a very short. And then so that we can allow the department to start working on the responses. But members, one of the issues that I think now that we partially think we have come to the end of the oral hearings, I would ask political parties, at least by Wednesday when we meet, we should have identified issues which we think might be a constitutional challenge. For instance, I do think that one of the issues that we would need to be careful around it is the issue of the bail, given Section 35 of the Constitution. I think there was also an issue around the register being open to the public. But I think members would be able to identify also other issues, because I would suggest that once we have compiled a list of all those issues that we think that there might be a constitutional challenge around them, and as we ask for a senior counsel's opinion how they should be crafted so that they meet the constitutional muster. We would want to start that process very urgently so that it does not delay the adoption or the processing of the bills. At least if by Wednesday after the meeting we can indicate, so that we can have the speaker assisting us with that kind of a resource, so that we do have a proper legal opinion. A bill or a legislation of this nature, if we get one thing wrong, it can be reversed for many years through legal challenges. And I think we must do whatever we can to ensure that we have applied ourselves correctly. I think that is the first issue. The second issue, from the way I heard the presentation, there are two issues that we must be focusing on. One is the texture of the bill of the bills, that is going clause by clause and everything, and ensuring that it meets the constitutional requirements. But I think people who have made their submissions are quite concerned about the state of readiness, the capacity of the government to implement these particular bills. And I would think that as a committee, we must not be blind to that concern. I think it's a genuine concern. It's a serious. Honorable Jelle. I think it's a. Honorable Jelle, can you mute your mic?
I muted it. I thought that you were talking to me, Chair.
Okay. So I think that we cannot be oblivious to those concerns. I think they are genuine concerns. And there were suggestions that I think they were made yesterday by Honorable Mfokeng, and then they were repeated by Honorable Swart today. And I think the last organization, the Women in Dialogue, they've already they made the same issue. I think there has to be a way, before the bill is passed, we have to get a state of readiness from all the departments at the level of the DGs or the ministers, because it would also be irresponsible of us to pass a bill that is not going to be implemented. We have to get a state of readiness from all these departments to a social development, its Department of Health, its Department of Basic Education, its Department of Higher Education, its Department of Justice, its Department of Police. Those are the bills that, those are the departments that are, I think, in the bills have been listed. We have to get from them the state of readiness. Honorable Mfokeng asked a question about the issue of budgets. How much has been allocated for the implementation of these bills over the MTF? For instance, there are issues that relate to your rape kits. There are quite a number of issues, because when we pass this bill, let us not have a situation where we create higher expectations and then everybody would be happy that the Parliament has passed a bill, and then after 6 months everybody is very disappointed because the state is not ready to implement the bill. Let's get the true state of affairs. I would suggest that before the bill is really passed, we do get that state of readiness from the department. But there's also another department. In fact, the portfolio committees, I think they should be invited. The portfolio committee is concerned, but we are told that there is a bill by social development about the support of domestic violence. There's a bill that they are busy with. I think it would be important that we confer with them so that there are no contradictions between our law and what they would have passed. So there's going to be a lot of work when we deal with this particular legislation. We have to do a lot of consultation even with other portfolio committees and the departments to ensure that we don't do malicious compliance, that we are happy that we have passed the bill, but we did not do due diligence. Let's do everything in our power to ensure that by the time the bill is passed, we are reasonably comfortable that even things that cannot be implemented immediately, but there is a project plan by the departments, because all ministers by cabinet are required to show when they present a bill to cabinet, they are required to indicate the financial implications, the implications to the vulnerable groups, the implications to the constitution. So these things are standards. So we will not be asking them something that it's out of this world. But we need, as Parliament, to get an assurance for ourselves that the bill, there is an adequate state of preparations and they're ready to implement the bill. It's not an order, so as a result, I think I would like to get the views of the members. I'm not making a ruling. I think the issues that I've raised, I think they would need a buy-in from the members so that it does not just become the chairperson's views. I would like to hear the members, what is their view on the issues that have been raised before we close.
May I speak, Mr. Chair?
Honorable Breitenbach.
Thank you. I agree with all your points and all your proposals. I think they're eminently wise, and we will support them.
Thank you very much, Honorable Breitenbach. Other members?
We agree, Chair.
No, thank you very much. So we will have to develop a program, Secretariat will have to develop a program that will incorporate all of these issues and the things that we want to achieve to ensure that we produce a good bill that has got an impact to our people. Members, let me thank you very much. You have applied yourselves diligently. It has been 3 days of hard work. Thank you for your cooperation. I think South Africans are proud to have public representatives like yourselves and across parties. Thank you very much. I think the meeting is adjourned.
Thank you, Chairperson.
Thank you. At least Honorable Breitenbach, it was before 4 o'clock. So,
Thank you, Chair.
So you can play with your dog. He's gone. She's gone.
Thank you, Chair.
Thank you very much.